Planning Board to order. It's 6:03. First item on the agenda is a roll call of members present. So Diorio here.
Hurwitz here.
Linda Lowe here.
Shamshinia here.
Only one who's not here is John,
So
so.
do it. Okay, very good. Next item on the agenda is the pre-roll. Prospective member attendance for June 2nd. So again, Diorio, I plan to be here, although I am once again being called to the Westerly Zoning Board of Review, so I may be tardy in arriving at the meeting, so whatever that's worth.
Ron
Other members?
Hurwitz here. Ron Hurwitz here. I plan to attend on June 2nd.
Keith Linda Lowe here. Yes, June 2nd, I'll attend.
This is Emily. I plan to attend June 2nd.
Outstanding, thank you.
Oh, 1 second. I'm allowing Carolyn to talk. She signed in with her computer initially, so I'm just updating that. Oh, John is here as well.
Everybody good?
Should be.
Okay. Before we get down to our first item of real business, we have a couple of administrative issues to attend to. First one is at Talia's request.
So I can't cite the law off the top of my head, but when minutes are completed, they have to be provided to the board within 35 days or the next regularly scheduled planning board meeting. And honestly, there's no way that I'd be able to have the minutes for this meeting for the next meeting, which is going to be on June, let me just pull up the calendar, June 2nd. So I would like to request an extension until at least the second meeting in June for these minutes.
Thank you, Talia. I'm perfectly okay. This is Al Diorio. I'm perfectly okay with that. I don't know if we need a motion to that effect. If Maggie is out there in cyber world, if she could perhaps comment on the correct format here.
I am out here in cyber world. Good evening. So I would suggest that you not vote on that, and that I will work with Talia to facilitate this for her. You know, we can't vote to violate a state statute and to extend a time frame. That having been said, I do believe that the 35 days is probably sufficient under the statute, but since I don't have it in front of me, I will consult with Talia tomorrow or the next day. And but I wouldn't suggest that the board vote on such a thing. Plus, it's not on the agenda. You can't vote on it anyway.
Very good. Thank you, Maggie. So we'll simply leave it in your capable hands, yourself and Talia, to work this through to come as close to complying with the statute as possible.
That's correct.
Outstanding. Very good. The next administrative item that I'd like to bring up is I'd like to recommend a revision to this evening's agenda. Specifically, I would like to direct the board's attention to the second item under new business. That would be the master plan public informational meeting for the Skunk Hill Road Solar Project. Now, my understanding is this applicant is requesting a continuance for this application. So the reason that I'm suggesting or requesting the board's consensus on a revision to the agenda is there may be many folks in the audience anxiously awaiting the emergence of this agenda item. And I would feel badly if they were sitting out there forever only to find that it was being continued. So again, I'm going to rely on Maggie. If I've got this right, I don't know if we need a motion to do this. I certainly don't object to a motion, but I'd like to have a consensus at the very least that we can attend to this item first up, provided that the applicant is out there and can give us his formal request for the continuance.
Mr. Chairman, that's perfectly appropriate. It is in fact an administrative matter, did not need to be on the agenda for that kind of a purpose. And it's my understanding that there was a defect in notice, and so the board couldn't proceed anyway. So why don't you bring up the applicant and its attorney or the attorney and let them be heard and move this along.
Outstanding. Thank you so much. So may I request, is the applicant and/or their counsel for the Skunk Hill Road Solar Project in attendance this evening?
This is Talia. Mr. Craven is in attendance. Please press *9. All right. And then press *6, please. And then please state your name for the record, Mr. Craven.
Okay, it's Robert Craven. I represent the applicant for the Skunk Hill Road Solar Project, known as Skunk Hill Road Solar LLC. And may I go forward with my request, Mr. Chairman?
Yes, please do.
Maggie Hogan, your counsel was correct. Ironically, apparently there is in using the computer or when they were trying to generate the notice for the newspaper ad, apparently they pressed the button for the address thinking that Hopkinton would come up, and it came up as Exeter. And as a result, there's a defect in notice that we advertised for a hearing of this nature for 145 Skunk Hill Road in Exeter. Obviously, as defective notice, it would be inappropriate for it to go forward. I suggest that it would be, reversible error, and they'd send it back anyways. And besides, we take the notice to this project really important. It's a really important issue because the folks in Hopkinton are very interested in this and what happens to it. So we would be requesting that a continuance, and if I could suggest a date for all the parties involved and coordinating, it would be your first meeting in July, which is July 7th. That would be my request, Mr. Chairman.
Very good. Thank you. I'm going to, I acknowledge your request. However, I'm going to defer to Jim. He's the master scheduler here to see if that
Okay.
is a viable viable date for us.
I think Jim might be a town planner. I think that's workable. It's around 4th of July, so.
Jim, we can't hear you.
Can you hear me now?
That's much better,
Yeah.
thanks.
Put my mic on. I think that July 7th is probably workable. We have a couple of meetings before that, 2 in June. I'm sure we can fill those up plenty. And, the problem with July 7th is it's right around July 4th. And hopefully, I don't know if we could get a scope of what board members are going to be here around that time or away. Be nice if we had a
That would be
quorum.
appropriate.
Yeah.
So if you will, this is Al Diorio, a pre-roll for July 7th? Is that what
Yes,
someone suggested?
to the best of their ability. Yeah.
Understood. So Mrs. Diorio, as far as I know, I will be here.
This is Ron Perlowitz. I will be here.
Keith Lindelof, I'll be there.
This is Emily. I plan to be here.
Sounds like July 7th is doable.
I think it's doable.
So if the planning board members are in agreement, could I have a motion to continue this particular application to our meeting of July 7th?
This is Ron. I'll go ahead and make that motion. I'd
I have
like
a
to make a motion to,
I'm sorry, go ahead, Ron.
So I was just gonna flesh it out if that's appropriate, or if you'll
Oh,
just
yeah,
take the motion
yep.
the way.
Oh, go right ahead, go right ahead.
I'd like to make the motion that we continue the Skunk Hill presentation until July 7th planning board meeting.
I have a motion.
This is Emily.
This
I'll
is
second.
Carolyn, I'll second.
We have a couple of seconds. Outstanding. Any further discussion on this topic? Otherwise, all in favor? Diorio, yes.
Krelwitz, yes.
Limbo, yes.
Light, yes.
Shamshini, a yes.
Very good. Anyone opposed? Hearing none. Applicant, July 7th. Thank you.
Thank you very much. Thank you for your consideration.
Very good. And then the last thing before we jump into our first item under old business, I'd like to again suggest we have 2 items on our agenda. I'd like to suggest to applicants, the audience, et cetera, that we talk about perhaps 2-hour timeframes for each of those applications. Again, I'm not suggesting that we need to eat up 2 hours if 2 hours is inappropriate, but let's try and keep it to within that time frame so that everybody has an opportunity to be heard this evening. So with that said, the first item under old business is a 3rd master plan public information meeting. Major land development project Stone Ridge at Hopkinton, AP 11, lot 47A, 0, Palmer Circle, RI 95 LLC applicant. Now, my recollection is that we left off having concluded the applicant's presentation. The planning board members, as a body, I suppose, deferred many of their questions, comments, and concerns so that we had a little bit of time to hear from the public. So there was a little bit of public comment. And what I'd really like to start with this evening is I think we have an opposing counsel for this application. So I'd like to suggest that we start by hearing that and then move to the general public for comments. Planning board, members, you okay with that approach?
Yes.
Sure.
Yep.
Yes,
Okay, very good.
Do we have, Mr. Chairman, pardon me.
Yes, yes.
I'm looking at the list of participants and I'm not sure where I can see them all, but do we have a counsel for the applicant in the audience?
This
Yes,
is
we do.
Talia. So
Okay.
Maggie, this is Talia. I've already made Bill and
There he is.
Sergio panelists as well as Mr. Squires.
Great, Sam. All right, just want to make sure everybody was here. Thanks.
Very good, thank you. So, Attorney Squares, are you out there?
He is.
I'm here, Mr. Chairman. Good
Thank
evening.
you.
Good evening, Mr. Chairman, and good evening, members of the board. I do have 2 expert witnesses with me here tonight. Peter Friedrichs is our planning expert. We also have Linda Steer, who is a wetlands and wildlife biologist. So at some point, I'd ask that they be promoted to panelists too, so they can testify. But before we get into that, I'd like to return to a procedural point that I raised back at the first master plan hearing back in October. I think it's become a bit of a thornier issue now, and the issue is this. The applicant is proceeding under the ordinance, the PSES ordinance that was adopted on January 22nd, 2019. And the issue with that is on page 7 of the PSES ordinance, subsection D, it provides, quote, the planning board will review PSES proposals in accordance with the process specified in the development plan review ordinance, end quote. Now the development plan review ordinance, that's, as you know, is set out in chapter 13.5 of your code of ordinances, article 3, sections 13.5-7 through 13.5-73. That is distinct from what's before you tonight. What's before you tonight is a major land development application, the master plan stage. And those are two distinct processes. The development plan review process has enabling legislation in the Zoning Enabling Act. That's Rhode Island General Laws 45-24-49. The major land development process has a separate enabling legislation, and that's in 45-23, a separate chapter. And in your subdivision regulations, the major land developments are reviewed on through sections 8.3 and 8.5, and development plan review is reviewed through section 9.4. That was raised in October, and at the time, I argued that it was required that a development plan review application be filed in addition to the master plan application. But the reason that that issue is a lot thornier now is that since October, that PSES ordinance from January 22nd, 2019 has been repealed and replaced, and the use proposed by the applicant is not allowed under the current ordinance. And so, in order to be considered under the prior ordinance, they need to be vested. And in order to be vested, they need to fall under section 12 of your zoning ordinance. And what that requires is that any application that's submitted that's substantially complete will be considered under the ordinance in effect at the time it was submitted. So the issue is that, to my knowledge, the only application submitted by the applicant is a major land development master plan application and not a development plan review application. And that the PSES ordinance that they would like to be considered under specifically provides that PSES projects will be considered under the development plan review ordinance. Now, just because they filed under the major land development application, that does not supplant the need to file a development plan review application. In fact, in your own subdivision regulations, section 9.4.1, it provides that a subdivision or major land development application can be considered at the same time as a development plan review application, but that's only upon an affirmative finding of fact that both review processes meet the intent and spirit of the requirements of the development plan review section. Now, the only way you can do that is if you have both applications filed and both reviewed. And the key point here, to my knowledge, no development plan review application has been filed, and therefore they would not have vesting under section 12 of the zoning ordinance. That was raised back in October. I didn't get a response then, but I wanted to raise it now. And I'd leave it to the board whether you want to address that further now, or whether you'd like us just to present our expert witnesses at this point.
Very good, thank you. I think on this topic, I've got to either defer to Jim or Maggie.
Mr. Chairman, I would suggest we give the applicant's attorney the opportunity to respond.
Okay, applicant's attorney.
You're muted, Bill.
I'm sorry.
There you go.
Thank you. Thank you, Mr. Chair. Yeah, I thought we were way past this this issue. There's a differently ordered process that exists under the general laws for major land development projects, and they're actually defined in 4524, but the procedure is provided for in 4523, the major land development project process. And that's where you have two or more uses, lots, or structures that are being proposed, as opposed to a single use on a single lot involving a single structure. So the major land development process is the required process for a major land development, and it has the multiple phases that the board is used to and that we're following here. We had a pre-application meeting. We went to a master plan submission. The master plan submission, as part of the major land development process, received a certificate of completeness as a major land development project, consistent with the master plan level of review. The differences in that, if we were proposing one use involving one lot without multiple structures, and in this case, we started off with a larger commercial building, but we still have a commercial, a commercial building. So when you have a major land development, you don't evade one requirement of the underlying ordinance in terms of what needs to be submitted. But those items are submitted in a different sequence. You have the ability to go for a master plan first, achieve your vesting as a master plan, get your certification of completion as to what is required for the master plan level of review. All that's been done. And then at a more detailed, at a more advanced stage of the proceedings, you come back with a preliminary plan review. Probably half of our presentation last month was on how much more robust this submission was than is required under the master plan stage of review, but how in the future things like decommissioning and other issues like that will be dealt with as part of the final plan stage of review. So there's nothing in the PSES ordinance that even addresses this issue very clearly. When you have both you have a major land development, obviously you've got to follow the major land development process, or Mr. Squires would be saying that that shouldn't have been followed. The application is the same, the plan is the same, there's no different plan, there's no desire to evade any requirements. In fact, when there's another section of the ordinance, section 13, the same one, that says that if a parcel is zoned to allow PSES use, then the proposed PSES project shall be referred to the planning board for master plan approval. A major land development project where you have so you've got the ordinance that Mr. Squires is relying on saying two different things: master plan, major land development, and development review. You've clearly got something that's defined as a major land development project, because we've got two structures that we're dealing with. So it is a major land development project. That makes us entitled to a phased review that starts with a master plan. We've got a certificate of completeness for a master plan. We're before the board, and I don't think this issue has any merit. There are a lot of major land development projects. If things are provided for in the major land development regimen, that's a more robust phased issue. It's got multi-stage vesting. There are the board knows that's the more complicated route. And out of an abundance, of caution, without evading a single requirement for submission, we felt the safer and more correct way to proceed here is as a major land development project. And that's how we were certified as complete. And that's how we've been proceeding for 4 months.
Mr. Chairman, if I could just briefly respond, and I promise I'll keep the comment quick.
Sure.
So I think we're in agreement is that the major land development project is distinct from the development plan review process. The point where I would disagree is that just because they're distinct, that does not mean that one review process can supplant the other. The PSES that they want to be vested under clearly says development plan review. And so the whole reason you have section 9.4.1 of your subdivision regulations and land development regulations is to deal with this exact situation where you require both development plan review and master plan review. And it says they can be combined for the same review process, but it requires an affirmative finding. And that's right in your subdivision regulations, your land development regulations, 9.4.1. So there are two review processes here. One doesn't supplant the other, they're both required. And the question is, what application is required to vest them under the PSES ordinance that's been repealed that they want to be vested under? Well, if you read that ordinance, it says development plan review. And I understand what Mr. Landry says is that the three-part stage of the major land development review, it makes it so that you can defer some detailed plans to preliminary plan stage. But when the ordinance says development plan review, you need to come in with a development plan review application and all the checklist items for that stage. And so I would argue, because they didn't file that they can't get vested under the PSES ordinance under section 12. Thank you.
Okay, very good. Thank you both for your opinions. Jim, if you have anything to add at this point, great. Otherwise, I'm prepared to continue.
I would like to see the board continue with review of this application.
Here we go. Very good. Thank you.
Mr. Chairman, at this point, if it's okay, I'd like to call Peter Friedrichs as our planning expert.
There you go. Yes, please.
Thank you.
Mr. Friedrichs, to unmute yourself, please press *6 and then state your name for the record.
Hi, my name is Peter Friedrichs.
So, is it the common practice for the board to swear in witnesses, or is that not necessary?
We have not been doing that throughout this application, so
Okay, that's fine.
I'm going to say just please continue.
Okay, thank you. Mr. Friedrichs, could you provide a little bit of your resume when it comes to your planning expertise?
Yes, I believe the resume was provided last fall. I don't remember the specifics of, I believe I spoke at one of the meetings last fall and provided an overview then, but I'll happily repeat what I said back then. My name is Peter Friedrichs. I'm the city planner in Newport. I've been there a little over 2 years. Prior to that, I was the director of planning and economic development for the city of Central Falls. And I have been a certified planner with the American Institute of Certified Planners since 2019.
And have you testified as an expert planner previously?
Yes. Not in, well, I think previous, in the fall here in Hopkinton on this matter, but in Warwick and then also in Exeter.
Mr. Chairman, I'd ask that Mr. Friedrichs be recognized as an expert in planning.
Yes.
Thank you. Mr. Friedrichs, did you get an opportunity to review the application submitted by the applicant on the Stone Ridge project?
I did, yes.
And have you formed an opinion, an expert planning opinion with regard to that application?
Yes, I mean the application has changed a bit over the months, but from what the latest I've seen that was at the last meeting, I have reviewed that and I provided a report on that, and I'm prepared to speak on that proposal this evening.
Okay, and can you speak on that, what your opinion is with regard to the latest proposal?
Yeah, so I think my report really details my analysis of that proposal. And it's my report's focused on the 4 findings required under the Subdivision Act, which is the state law that outlines the land development process that the board is going through right now. And I just want to add a little bit to that this evening, focusing specifically on the comprehensive plan and that required finding for consistency with the comprehensive plan. And I'll speak a little bit about the land development process. So this site in question is a planned development that is what the zoning map amendment assigned to this specific site, and it requires review through the land development process. And being a planned development, that means that the design of the development must be approved by the planning board prior to the establishment of a use on the land. In accordance with Rhode Island laws I've mentioned, the planning board must make affirmative findings based on the evidence presented in its review prior to making its decision on whether or not to approve the development and in turn permit the use. The size of the development can be no larger than the maximum size that will be determined by the planning board to meet the required findings. The applicant has amended the master plan submission to address some of the concerns expressed. It is my professional opinion that the scale of the proposal has not been sufficiently reduced to demonstrate compliance with the required findings, including the comprehensive plan. The project was originally proposed to be equivalent in size to the Block Island wind farm. Reducing it by the equivalent of 1 turbine is good, but the project still proposes the equivalent of 4 gigantic wind turbines. 23.5 megawatts is enough power for over 4,000 homes, or more than the entire population of Hopkinton. This one project will achieve Hopkinton's renewable energy needs and then some. I will repeat what I said in my report, which is that if Hopkinton is intending to be a regional energy supplier, the comprehensive plan should be explicit. The citations in public services and facilities and natural resources are not enough to demonstrate consistency for such a large-scale project. Regarding the use, the general standard is that solar is a utility use that does not fit neatly into the base zoning category of commercial. The proposed development is for a utility, not commerce in the zoning sense. Little detail regarding the building has been provided, other than that the applicant no longer proposes to utilize it for energy storage. I trust the planning board agrees with me that the comprehensive plan does not envision the town's commercial and manufacturing zones to be solar farms. This is a terrible use of the zone's proximity to the excellent transportation asset that is I-95. I want to just quickly read the introduction to the economic development chapter of the comprehensive plan for some context here. Enhancing economic development opportunities in Hopkinton will lead to the growth of the town's tax base and labor force and improve the quality of life in town. In doing so, it is important for the town to create a balance between new development for economic purposes and protecting the natural environment and historic and cultural resources. This means new industries must be compatible both environmentally and physically with the rural character of Hopkinton. Current economic development initiatives have focused on light manufacturing, high technology, local commercial activities in village centers, recreational opportunities like hiking and camping, and agricultural businesses. If Hopkinton is going to get in the business of being a major energy supplier, it needs clearer language in its comprehensive plan. And the solar guidelines published by statewide planning a few years ago were very clear that they really were looking for comprehensive plan amendments in municipalities that were explicit about their approach to solar. And that's something that I think Hopkinton really needs. I just want to wrap up here by reminding the planning board about their ability to increase setbacks from residential zones. And I will conclude, and you're going to hear from another expert in a moment, that others have provided reasonable, credible testimony regarding concerns with compliance with the zoning ordinance and significant negative environmental impacts. And I just want to say as a final statement, the planning board cannot approve a project if it does not meet the required findings. Thank you.
Peter, one last question.
Yes.
Just for the record, I'm going to ask you, in your opinion, does this project meet the first finding, which is the proposed development is consistent with the comprehensive community plan and or has satisfactorily addressed the issues where there may be inconsistency? In your expert opinion, has this application done that?
I took a careful look at the changes that were made this spring, and I do not think that it meets that required finding.
Okay, thank you. Mr. Chairman, at this point, I'd like to call Linda Steer. She's an expert wetlands and wildlife biologist as our next witness.
Yes, proceed.
Thank you.
This is Talia. Please press *9. Mr. Squires, can you please communicate to your next speaker that they have to press *9 so I can identify them within the participant window?
I will do that now. Thank you. Um, So I could identify her too as by her cell phone, which is showing on the screen, if that's okay. Would that also work?
This is Talia. Please tell me what the last 4 digits are.
They are 0083.
I don't see anyone with that last 4 digits of the phone number.
I see her name under the call-in listeners.
All right. Okay, and her last name is Steer, correct?
Yes.
Yes.
All right. I had to find her manually.
Thank you for that.
And she'll have to unmute by pressing *6.
Hi, Linda, can you hear me? Linda, we can't hear you. She may be having some technical difficulties now. I'm just going to give her a call, and maybe there's a way we can get around that by just, if I put her on speakerphone on my cell phone and then just had her come over the mic on my computer. So I'm going to give her a call now. All right.
Okay, sorry.
All right. Can you hear Linda? Go ahead, speak and see if the planning board can hear you, Linda.
Okay, my name is Linda Steer. I'm the president and principal wetlands biologist at Applied Biosystems.
And is everybody hearing that?
Yeah.
Okay.
Yes.
Linda, could you give a little bit of your resume, please?
Certainly. And I apologize for the Zoom meeting. This laptop isn't cooperating. I have a bachelor's of science in zoology and then a master's of animal science in wildlife management and wetlands from also University of Rhode Island. I have a number of professional registrations with Society of Soil Scientists of Southern New England, Rhode Island Association of Wetland Scientists, the Rhode Island Natural History Survey, and the National Society of Wetland Scientists. I've been in business for 32, but I have 40 years of experience working prior for Rhode Island Fish and Wildlife and the CRMC, the Rhode Island Coastal Resources Management Council. So I've been started Applied Biosystems in 1986, and I'm still here.
And Linda, have you testified as an expert before?
Yes, times.
Okay. Mr. Chairman, I'd ask that Ms. Steer be accepted as an expert in wetlands and wildlife, as a wetlands wildlife biologist.
Yes, I'm very familiar with Linda's credentials. Very good.
Thank you. Ms. Steer, have you had an opportunity to review this application, the Stone Ridge application, and most particularly the latest iteration of that application?
I've looked through all of the existing documents and also did a personal review, primarily with the GIS and the overlay maps, as well as reading through the Mason and Associate document and the Natural Resource Services document that were prepared for the applicant.
And have you formed an expert opinion regarding the application?
I have. The search is going to have a significant
Linda, you're breaking up a little bit. Linda, you're breaking up a little bit. Is there a place you can go with better reception?
Yeah, probably. We have one window at our house we can stand in to talk on the phone, and I moved. So that it will have a significant impact, in my opinion, on the wildlife habitat on this particular site.
And what caused you to reach that expert opinion?
Well, in addition to the two reports that I just cited by that were done for the applicant, there are a number of other items that I feel are important to acknowledge in the site. One is the fact that it's documented as a 500-acre unfragmented forest in the 2015 amendment to the Rhode Island Wildlife Action Plan. So those areas are an overlay in the GIS, and they're designed to capture habitat with high conservation value by identifying these large and connected, connected blocks of common habitat, as well as based on rare, resilient, or productive natural systems. So they're designed to protect natural diversity of both plants and wildlife species, and they're to prevent fragmented forest areas that then have a large impact on migratory birds, certain types of wildlife, mammals, and plants that need large areas of undisturbed property. Some of the bird habitat, such as scarlet tanagers, wood thrush, a number of warblers, which was also mentioned in the Mason and Associate letter, need these large unfragmented pieces for nesting habitat. The other item is that it was also identified as a conservation opportunity area, and that was also a GIS layer, which again is to protect these unfragmented areas. The eastern portion of the site has a groundwater recharge area and a wellhead area nearby. And it's also identified as a climate corridor by the Nature Conservancy, which was designed to also protect connectivity of species and habitats, and also protect carbon sinks, which are becoming more and more important with climate action and increased temperatures. In a forestry survey report in 2008, they determined that 11% reduction in forested areas from a 1998 report, 10 years prior, was due to residential and commercial development in rural areas. Again, it results in a loss of wildlife habitat and other natural losses. As to also the historical and archaeological items, I'd just like to mention that this property is a link to Rhode Island's path. And I know there's other people discussing Narragansett Trail and maybe ceremonial mounds and the stone walls, which also are habitat for wildlife, for snakes, salamanders, rodents. And there's also the Warden Cemetery. lifted and have access for the relatives of those people. Finally, the Wild and Scenic Stewardship Council letter included it, and
Linda, you're breaking up again. Linda, you were breaking up again.
Sorry, I moved.
That's okay.
That Wild and Scenic designation was approved by Congress and includes Wood River and the Canachet Brook and most of the watershed that this property is in. And since it was approved by Congress, I have questioned whether it also means the northern long-eared bat, which uses tree habitat for breeding and just residence during the summer, and therefore would tree cutting be prohibited within a quarter mile of the Canachet Brook because of the federal approval of this scenic and wild.
So Linda, I guess maybe it's appropriate now for me to ask you this just to get it there on the record. You might have touched on this to start, but in your expert opinion, do you believe that this will have no significant negative impact, environmental impacts from the proposed development, which is one of the required findings by the planning board? Do you have an opinion on whether there will or will not be significant negative environmental impacts?
My opinion is that this would have a very large, significant environmental impact because it results in the clearing of about 100 million acres of forested land and wildlife habitat.
Thank you. So with that, Mr. Chairman, we've presented our two experts. We've made our legal argument on the commercial special zone, which was dealt with at the last meeting. I made the legal argument on the vesting issue tonight. But beyond that, even if you did not decide our way on the legal arguments, you still have those findings of fact that you're required to make. And one of them has to do with consistency with the comprehensive plan. And the other has to do with whether there will be no significant environmental impacts from the development. And the experts that have testified tonight have both testified that in their expert opinion, this application does not meet either of those standards due to the scale of the proposed project, the amount of clear cutting, and the environmental impacts. They do not meet those standards. So with that, I know that there are a number of other people here from the public that would probably like to testify, and that you do have the time limit that was established. So I will end the argument in our testimony at this point, and I thank the chairman and the members of the board, and I'd ask that you vote to deny this proposal. Thank you.
Okay, very good. Thank you. So that having been said, I'm prepared to go to the general public for comments and concerns.
Mr. Chairman?
Yes, I'm sorry. Yes.
Before you do, you want to offer the opportunity to the applicant's attorney to cross-examine either of those witnesses.
Okay, forgive me. So I guess that's the more appropriate approach. Mr. Landry, if you care to do that, this would be your opportunity.
I just have a couple of questions for Ms. Steer. Steer, you are aware this is a commercial zone, are you not?
Well, she actually hung up the phone, Bill, but I can get her back. But there wasn't cross-examination of Mr. Landry's experts last night, the last time we were here. I wasn't sure if we were going to have cross-examination of those experts. And I'm not sure, if we are going to start cross-examining, I think we'd have to cross-examine, or at least have the opportunity to cross-examine everyone. And the only issue is
Did you inquire?
Did I? Well, I didn't have the opportunity to, I don't think, but.
Hey, this
Listen,
is Carolyn.
yes, Carolyn, go right ahead.
I'm sorry, Al.
Nope, go ahead.
I would think the planning board at a minimum would have the opportunity to cross-examine your witnesses
Of course. No,
at a minimum.
yeah, I appreciate that.
Okay.
Appreciate that.
Yeah, my question Linda Stair is still on the computer, so maybe you can get her attention back. But I had a question.
Well, Carolyn,
suggest-
yep, let me interrupt, Al Diorio. So listen, we're kind of in the middle of Maggie's recommendation that Mr. Landry have the opportunity to cross-examine. I think we ought to stay on board with that before we start opening it up to everybody and anything in order to
You're
remain somewhat
absolutely
focused.
right. You're brilliant, Al. Yes, you're right.
Actually, if it were up to me, I would move to the general public, but I'm following Maggie's advice because that's what we do. So anyway, if we could get Ms. Steer back on the radio.
I believe he's attempting to do so.
There we go. Very good.
She's on now, Mr. Chairman.
There we go. Very good. Mr. Landry, you had a question.
I just had a couple of Linda Steer. Linda, can you hear me okay?
Yes, I can.
All right. First off, are you aware this property is zoned commercial?
I understand it's zoned special commercial, yes.
And that at least portions of it were previously zoned light industrial, correct?
Correct.
And the last zoning approval for the project contemplated a resort with multifamily housing and hotel and various other forms of development throughout a golf course throughout large stretches of the property. You aware of that as well?
I am, but that project did not happen.
Well, but is it your position that the zoning and is the property designated as a conservation area in the zoning ordinance?
I'm not sure of that, but I know it is on layers of the GIS documents at the RIDM.
Yeah, it's not designated in the comprehensive plan as a conservation area, is it not?
That I'm not sure of.
Mr. Squires asked you about the findings that the planning, by the way, were you here during the testimony of our witnesses on how the wild and scenic river impacts are going to be protected and access to that area improved? Mr. Mason's testimony, Mr. Moorhead's, Mr. Rabideau's testimony that all required wetland setbacks.
But she hasn't been here. We don't need to reiterate the testimony. She wasn't here.
Excuse me, Mr. Squires. I was very patient during your examination. Your witness testified to a lot of things. And one of the things she didn't testify about was the measures that the professionals who have been with this project for a very long time have designed to protect all of the various interests that you described. Were you here during that testimony?
No.
Okay, and you were also asked about a finding as to environmental impacts. You're aware, are you not, that required finding by the planning board has to be made based on the final plan, not on the master plan?
I realize they're just starting this process, yes.
I'd object. That asks for a legal conclusion.
Well, you asked her about the findings. I just wanted to see if she actually knows what the finding is that's required. It has nothing to do with the master plan stage of review.
That's a legal argument.
Well, we can both read the findings. But you are aware, Ms. Steer, that after the master plan review, the project is then reviewed by the Rhode Island Department of Environmental Management, and the various environmental issues that you're an expert on, including wetlands, are evaluated, and all of the impacts are considered in connection with the DEM review, and that the results of that review become available to the planning board as part of the preliminary plan stage of review. Did I state that correctly?
I'm not sure I follow you. I was asked to give an opinion about the habitat and wildlife and habitat of the site.
And you are aware of what DEM reviews, are you not?
I am, yes, but at this point, there's no application from this applicant to even review at DEM.
Right, because that's not something that's done until after the master plan stage of review, correct?
Correct.
That's all I have to.
Okay, very good.
So I guess since I didn't anticipate that, maybe I just sum up my final argument to the board and just respond to some of the points raised by my brother. Two things came to mind real quickly. The first is that this project, if you review it as a major land development, has 5 findings you need to make at both the master plan stage and the preliminary plan stage. And those findings require both a comprehensive consistency with the comp plan and no significant environmental impacts. You have to make it at both stages. And so the testimony here tonight is entirely relevant to that. And frankly, it's not really relevant at all. Whatever project might hypothetically go onto this parcel, because you have to look at this particular project and decide whether it meets the standards for that you're required to apply. So you've had 2 experts testify that they do not. And in addition to the other legal arguments that we raised, for that reason, we'd ask that it not be granted. Thank you.
Very good, thank you. Okay, now let's go to the general public. So for those in the audience who may be wishing to be heard on this application this evening, this would be your opportunity.
This is Talia, so I'm going to do what I usually do, which is read off the last 4 digits of a person's phone number or their name. Once I do that, please press *6 and then state your name for the record. The first speaker is Mr. Jeff Rossi. And to unmute yourself, press *6. I think I said that, but always bears repeating.
All right, can you hear me now?
Yes, please state your name for the record.
Jeffrey Rossi at 313 Woodville Alton Road. I was able to comment at the last meeting, and I recalled a couple points I wanted to make emphatically. I live on the Palmer Circle side. I live on the Lindbrook Golf Course. And I recall the floods of 2011 when the entire golf course was essentially a lake. Woodville Alton Road was breached at the overpass, and it was really quite out of hand. That happened when we had all that acreage forested up where this project is. And if those trees are removed, we won't have the benefit of that big sponge. And I think that a flood like that would be much worse. As well, in terms of noise abatement, when at Palmer Circle, the B2B complex was installed there. Once it was built, the noise from 95 was quite disturbing. And this is a much larger area that is going to be cleared, and it's going to, I lived in New York City. I don't want New York City here. It's going to be very, very loud. So with those things, in mind, especially the history of that flood, without those trees, all that entire area taken down, we're going to get washed away down here. I really hope that the planning board will keep that in mind when they make their decision. But other than that, that's my comment. So thank you very much for your attention.
Thank you.
Next member of the public, DJ Kushner. Please state your name for the record after pressing *6.
You're on mute.
I've given them the ability to unmute. They have to unmute themselves at this point, so they have to press *6.
So we're waiting patiently for someone to press *6.
Yes,
We'll give you a few more seconds and then,
we'll move on to the next caller.
Okay, wait, can you hear?
Here you are, Dana.
There you go.
Hi, thank
There
you
we
so
go.
much. Okay, we got.
Please
Here you are,
state your
Dana.
name for the record.
Hi, my name is Diana Kushner and I live in Blitz Creek Trail. Thank you so much for hearing me. Can you hear me?
Yes.
Okay, great. I am calling, I love solar energy and I consider myself an environmentalist. We have solar panels on our roof at home, but why I'm calling today, why I'm so concerned is that it's fairly common knowledge that when you cut down a forest and replace it with solar panels, you don't have any savings in carbon. It's a net neutral for carbon in the atmosphere. So my question is if we cut down the trees in Hopkinton, who wins? And I know it's not the people who live in Hopkinton. I know it's not the neighbors, the people who come here to hike, longtime residents. We're not getting anything from cutting down the trees and replacing it with solar panels. So I guess what I'm asking the board to consider is what do we want Hopkinton to be? Do we want it to be a beautiful place that people love to live in, that attracts people from all over the state? Or do we want it to be a clear-cut place of solar panels that aren't really giving much income to our community? And that hurts the environment, it hurts all the critters that live in it, everything else. So I think that's pretty much all I have to say. Yeah, it's just that the carbon footprint for the planet is going to go up if we do this. We're not helping the planet. We're not helping Rhode Island meet its carbon goals. Yeah, and there's other really wonderful places to put solar panels, but I don't think putting solar panels, replacing our forests with solar panels is a wise decision to make at this particular point in time. So thank you so much for hearing me.
Very
That's
good,
it.
thank you.
Okay.
Next member of the public, Eric, please state your name for the record after pressing *6.
Hi, it's Eric. I wasn't aware that my hand was raised. I was going to speak later if that's possible.
Okay, just raise your hand. We have a couple of other people, so just raise your hand now.
Because I spoke before, so out of respect for others that haven't, I spoke at the last meeting, so I wanted to let others weigh in.
You got it.
Thank you, Eric.
Last four digits, 8453. Please state your name for the record after pressing *6.
Hello, can you hear me?
Yes, please state your name for the record.
Hi, my name is Kevin Gregory. I live on 10 Red Fox. I'm the property that abuts the south side of the proposed project. First of all, I'd like to express my overall view. 16 years ago, my wife and I purchased land for our dream house. Our search led us to this beautiful Hope Valley. And as of now, to be honest, we kind of regret our choice moving here. The decision to build this dream house has developed into really a nightmare. It appears that solar has taken precedence over the popular opinion of this town. If my opinion counts for anything, please note that I don't want this to be approved on any level for multiple reasons. Displacement of wildlife, water and erosion issues, decimation of thousands of trees, and the removal of historic features. But it appears there's a strong possibility this will be approved, so damage control may be my only option. Please let me draw your attention to the plan review. Now, in the plan review on page 15, there's a statement made that says there are a few directly abutting residences to the south and southeast. However, a combination distance, and in parentheses, well in excess of 1,000 linear feet. Present thick, vast, mature vegetation, all but visually obliterate any direct line of sight. Well, unfortunately, that's a completely false statement. As far as a line of sight, my yard is basically void of trees and vegetation in the direct line of sight. There's no vast, mature vegetation as stated in that paragraph. I'll clearly see the developer's retention pond, the building, the dumpster in the driveway as shown in the plan. A chain link fence, shrubs won't remedy this issue. My backyard will resemble an industrial lot.
This is Talia. I'm sorry, Mr. Gregory. I can no longer hear you. I think you might have either muted your phone or I really don't know what.
No, I'm not on mute.
I can hear
I'm not
him,
on mute.
Talia.
Can you hear me?
I can hear him.
You can hear me?
Talia,
All right.
so hold on just a minute.
We have a
Mr.
green light
Gregory.
here?
Hold on,
I'm sorry?
please. Hold on,
Alrighty.
please. Talia, can you hear yet?
Yes, this is Talia.
Okay.
I think that we might have had an unstable internet connection in the town hall.
Okay, very good. Mr. Gregory, you may continue.
Okay, thank you. So what I'm saying is I'll clearly see the developer's retention pond. Now this is on the south side of their development. The retention pond, the building, the dumpsters, everything that's shown on the plan. And a chain link fence and shrubs will not remedy this issue on any stretch of the imagination. So basically my backyard will resemble an industrial lot. You know, and I understand it's commercial, but there's more than enough room on this site to move these structures. Plantings and a fence aren't the solution to this problem. The relocation of the building and the retention pond on the other side of the property would eliminate the impact of these structures on my property. Also, the location of the fence, it's relatively close to the property line, and I see no point in that. So, you know, if the fence could be located closer to the solar field, then, you know, that would be preferred as well. Also, I have engaged in legal counsel to file an appeal to the project in the event that the board doesn't see fit to take into account my concerns regarding the location of the building, pond, and fence and its proximity to my yard in the direct line of sight. My appeal will be based on the fact that my view of the building, pond, and fence, as well as my ability to see it from my yard, violate the town ordinance and comprehensive plan. Additionally, I do invite all of the board members to my residence, you know, maybe one at a time. And if we, you know, if that was an option, we can set up some times and, you know, please feel free to come here and see exactly what I'm speaking of. I have absolutely no problem with that. Additionally, I mean, you know, they have a tremendous amount of space on that lot. And if this does end up moving forward, putting the building and the retention pond and the fence, it wouldn't change, you know, moving them to a different location. It would not change the functionality of the purpose of their project. But it would definitely preserve my natural view. Again, as I mentioned, I'm not really for this project. I think there are some really, you know, disheartening byproducts of this project. But I mean, this right now is my grievance. That's it.
Thank you.
Thank you.
Next member of the public, Elaine Calderon. Please, even though I just said your name, state it for the record.
Elaine Calderon. I am the Hopkinton representative for the Wild and Scenic Stewardship Council. And I hadn't planned on speaking tonight because the planning board has our official advisory letter that the council put together. But I did want to clarify something that I heard the wildlife biologist mention. She was talking about a 1/4 mile and no cutting of trees within that 1/4 mile. Our wild and scenic designation of this watershed is a partnership. It's called a partnership wild and scenic designation, which means we have no jurisdiction over a 1/4 mile of those rivers. We are advisory only, and we cannot, there's no buffers, there's no setbacks. And this is because we're in a very populated area. The wild and scenic designation that is not a partnership are the type that you see out west, where there's vast amounts of land. And on those, that type of area, there is a 1/4 mile setback, look back for if a federal government type of project is proposed. So I didn't want the planning board to think that there is any 1/4 mile anything around any of these rivers. It's just an area we happen to look at. We may want to comment on it, but we have absolutely no jurisdiction, no setbacks, no buffers. There's nothing around these rivers. That doesn't mean that we wouldn't like to see more of a buffer around any of the rivers, certainly more than what DEM recommends. I would urge the planning board to look into that. But I just wanted to clarify that.
Very good, thank you.
Next member of the public, last 4 digits, 8222. Please press *6, then state your name for the record.
Hi, this is Joe Moreau. I just have a quick question. It was difficult to hear the witness. I believe her first name was Linda Steer. I also believe she said that the unfragmented forest was 500 acres. I would like to confirm that number, please. Is she still there?
I'd have to call her again. If the planning board would like me to do that, I can.
Well, did anyone else hear 500 acres?
Mr. Moreau, this is Attorney Hogan. I did as well, and I wrote it down, documented as a 500-acre unfragmented forest.
Okay, fine. That was my only question. I wanted to confirm that number. Thank you, Attorney Hogan. I appreciate it.
Sure.
Very good, Joe, thank you.
You're welcome.
Next member of the public, last 4 digits, 9060. Please state your name for the record after pressing *6.
Hi, my name is Steve Wheel. I live on Old Depot Road in town. Thank you very much for listening to a couple of brief comments I have. I've been through this so many times over the last, God, I can't believe that we're going on, what, a few years of these hearings. And I'm opposed to it, this particular project, as with most of the others in terms of size, the enormity of it, the impact. Again, no matter how many times I hear an attorney for the applicant state that all of the people that worked on his side are all environmentalists, I have a real hard time, and have from the beginning of these hearings back when each and every time they want to cut down, many times I should say, in these residential projects or areas, forested areas, that they're going to cut down thousands of trees to create this project. And it never made much sense to me how you can sit on one hand and say that you have an environmentally sound view of the world when you want to chop all of this habitat down for wildlife, et cetera. And I have heard others comment on that. So I'm not going to comment any further. It's just something that, it's the main reason, because it all stems, in my objection, it all stems from that, from the destruction of these trees that do such awesome things for us as people and animals. So before I sound too weird, I'll move on from that subject. I also want to make one other comment about something that was brought up last hearing, which was Mr. Prowitz had refused to recuse himself from this hearing in a vote. And I just was looking through my records, and I found another Facebook post that I think the Skolko should be aware of, that Mr. Prowitz commented on June 19th of 2019 on a Facebook post. And it was started out as, it looks like a community post where a person by the name of Jay Kersey made a comment and said, no more clear cut, trade the forest for brown fields. And a person by the name of Ronald G. Prowitz responded, and I quote, the anti-solar people have a professional lobbyist and an expensive lawyer, and many of the talking points they present are false and only agitate people. So those are the only comments I wanted to make. And I just think that there's a difference between advocating and sitting as a fair, objective person that can put away your bias. And I just would like Mr. Prowitz to really just look at it and see if it make jars memory and make a little difference. And that's all I have to say. Thank you.
Very good, thank you.
Next member of the public. Eric, state your name and press *6.
Hi, it's Eric Bibler. Can you hear me?
Yes.
Okay, I'm on Woodville Road. I think that this, just to get back to basics, this all comes back to the planning board, obviously, which is invested with the authority and the responsibility to make these required findings, under our subdivision regulations. And the findings are, not only required, you need to make positive findings on all the relevant points. And we talk a lot about the rights of developers when they have a certain zoning, availability of a certain zoning, but we should all be reminded that those rights are not unlimited. This board evaluates residential proposals all the time, and a builder may come in and want to put in 200 houses, and the board might tell him he can't do that. He has the right to build houses. He doesn't have the right to do whatever he wants. So there's a few things here that really leap out at me that I think have been touched on, and I just think they're worth remembering. One of the findings is whether or not this is fundamentally consistent with the comprehensive plan. This plan for development, not the concept of putting up some solar panels, but this plan for development. And the second one that's been raised here tonight pretty prominently is that it has to satisfy the requirement that it not have an significant adverse environmental impact. And we've had an expert testify that it's going to have a very significant adverse environmental impact. I think all the members of the board have had access to the recent study that's been circulating on the tremendous value of Rhode Island forests. We've heard on a number of occasions that there's no environmental benefit, and in fact, we're going backwards when you cut down trees, when you clear forests to put up environmental panels. There's no environmental virtue that attaches to that. As to the amount of the unfragmented forest, I do want to note that our own Conservation Commission, I believe, used a figure of either 1,000 acres of unfragmented forest or 1,300. I can't remember which, but I don't know how you measure or who the authority is on unfragmented forest, but we've been hearing figures that are substantially higher than 500 acres of unfragmented forest. And unfragmented forest has exceptional value. Unfragmented habitat is what the Nature Conservancy and Department of Environmental Management and various state agencies and conservation agencies strive to accomplish instead of having patchwork, pieces of reserve. I do want to direct the board's attention to just, one particular part of the report from the planning expert for the objectors. Mr. Friedrichs makes the point that although the town of Hopkinton's comprehensive plan has a couple of glancing references to solar energy, and most of those are in the context of the town's own consumption. There's a reference to a goal to adopt regulations that encourage, quote, small scale renewable energy installations. And I think this point has been relevant to all of us over the past 2.5, 3, 4 years. Mr. Friedrichs makes the point that there isn't any reference in the comprehensive plan to a goal or an objective of encouraging utility scale or industrial scale solar development. And we now have at least 3 of these that are huge systems, and another one tonight that was continued. We have Alton Bradford Road, Maxon Hill, Revity. These are all gigantic solar systems. There really is nothing in the comprehensive plan that even contemplates this. And you would think, as Mr. Friedrich says, that if the town of Hopkinton truly wanted to have multiple massive solar power plants in town, we would have had that discussion and we would have arrived at that conclusion. So I would say that his conclusion that this is this concept here tonight that's being presented is absolutely incompatible with our town's comprehensive plan. It's not contemplated anywhere in it. And then just quickly to get them on the record, I'd like to read some of the specific goals and objectives of the comprehensive plan that I think this would violate and I think should find a home in your findings when you deny this. First is goal con 1. It's not consistent with the conservation of Hopkinton natural resources, particularly the protection of the ground and surface waters. We've just heard a little bit about that. Goal con 2. It's not consistent with the conservation of Hopkinton's major natural features and of its traditional rural character. Goal NR1. It's not consistent with the preservation, conservation, protection of the significant natural resources of Hopkinton as an endowment for the future of the town. Goal H1. It's not consistent with the intent for Hopkinton to be characterized by safe, secure, and attractive residential neighborhoods. Goal LU1. It's not consistent with the protection of the quality of life and rural character of Hopkinton. Goal LU4. It's not consistent with the preservation of existing farms, wildlife, and wildlife habitat. That goes directly to the unfragmented forest, obviously. And finally, it's not consistent with economic development goals related to reducing the town's long-term energy costs, increasing our energy independence, or creating local jobs. Not going to create any local jobs, and this has nothing to do with the town's own energy costs and the town's own energy independence. So for all of those reasons, I urge you to deny it. And I don't know whether you're going to vote tonight, but I urge the members of the planning board to review a recent court decision that Solicitor Hogan provided to you for Boone Street Presby LLC versus Town of Narragansett, because in that you'll find boilerplate language that applies to the Superior Court review of your decision, right? And it's in every review, of every planning board decision that somebody contests. And what that says is that the court, the appeal authorities shall not substitute their judgment on the merits of the project, for the judgment of the planning board. The issues at hand are typically procedural and legal. So I just am only mentioning that to let you all know that we don't need to be, terrified of an appeal. You can vote the courage of your convictions. You can feel secure that if you judge this on the merits and you find that it simply does not satisfy these 2 required findings and you support it, the expert opinion of the objector and these goals and any others that, that you think apply, that I think your verdict will very likely carry the day. And I appreciate all of you. You've worked so hard for us over the past 3 years on so many of these, and you really are the guardians, of our vision for our future and our town's comprehensive plan. And this is really your moment in your decision. So thank you very much for listening.
Thank you.
Next member of the public. I apologize if I pronounced your last name incorrectly. I believe it is David Giever. After pressing *6, please state your name for the record.
Hello, can you hear me?
Yes, please state your name for the record.
Yeah, it's David Giever. I'm attending this only to basically hear the arguments for and against. I was listening in mainly because of the Skunk Hill issue, but you've postponed that. So I really, in general, I have the same complaints that most of the people have about large systems, be it where you're talking about for this particular project or for Skunk Hill. There seems to me to be adverse effects relative to comprehensive plan. So I'm simply going to chime in when the Skunk Hill arguments arise in July, but they'll be consistent with the arguments against tonight. Over.
I'm sorry, Mr. Giever. Does over mean that you're done speaking? I think that's jargon of some kind.
Yes. Sorry, military jargon. Yes, done.
Okay, thank you. I didn't want to cut you off if you had more. It seemed like you were done, but wanted to be respectful.
Done. Thank you.
Next speaker, Tammy Walsh. Even though I just said your name, please state it for the record after pressing *6.
This is Tammy Walsh. Can you hear me?
Yes.
Hi, Tammy Walsh. I live at 229 Woodville Road. After listening in to many months of meetings, I've not been convinced that this project is fundamentally consistent with our comprehensive plan. This is an extremely large project and will have a significant detrimental impact on the environment and on abutting property owners. There's been a lot of testimony, and I'm not going to rehash all of that because everybody's heard it. But for those reasons, I am opposed to this project, and I hope that the board will vote to deny it. Thank you.
Next member of the public, Cole Stephen, Lisa Lane, Hope Valley. Please state your name for the record after pressing *6.
Can you hear me?
Yes.
Great. Thank you. Hi, good evening. I'm Colleen Zeffin. I'm a Hopkinton resident, and I'm on Lisa Lane. I believe firmly that our comprehensive plan should be followed, to follow the guidelines that we have in place, to follow the plan to protect the rural areas, especially the wildlife and heritage of our town. I moved here 3 years ago, and this entire town was a real blessing to come out of the city and of northern New England cities. So it's a really beautiful place. I wanted to just make a comment that I think it is intellectually insulting to suggest that this project, which involves the clear cutting of so many acres of woodlands, to expand industrial massive solar on this scale, it harms the environment. It reduces and it reroutes wildlife that we depend on. We have eagles, osprey, owls, reptiles, bugs, everything that you can imagine. And our, like a wildlife expert had noted that they live in these walls. They live in these stone, these monuments. Even though no one can see them, they're there. And those resources have made this one of the most desirable areas of the state. Not only now, but thousands of years, people have flocked here, people have lived here, and we are in danger of just losing that. I just also want to mention that this kind of solar scale, development negatively affects the home value for my neighbors and friends who live near those plants. And I would really like to mention that that's a critical piece of having, the economy of this area hold up. And that's, the land that we do have, let's preserve it for our homeowners and just folks to live. I urge strongly the planning board to consider my position as a Hopkinton resident. I'm opposed strongly to the large solar scale development projects. Please vote to deny. I can only say that from the bottom of my heart, how much I love Hopkinton, how much I care deeply about the wildlife and the natural history of the area. And I want to preserve that aspect for generations. I don't want the time that we've even lost to be lost any further. And all of that is around us. It's silently underappreciated. The beauty, even though we can't see it, acres in, hundreds of acres in, and it might be overlooked, but it does surround us. It is one of the beautiful things about this area. I really appreciate you taking the time to listen to my position today, and I wanted to thank you all for your help on this issue. Thank you.
Thank you.
That's it.
Apparently, there is no one else in the audience wishing to be heard on this application. So let's return to planning board members.
Oh, we have one member of the public who just raised their hand.
Okay, well, we'll certainly entertain that.
0377, please state your name for the record after pressing *6.
Hi, my name is Tim Ward, and I am a Hopkinton resident. I live on River Road in Ashaway, and I would like to state, first of all, I appreciate the board's willingness to listen this evening to the residents, and thank you for your efforts on this project. And I'd also like to state that I am opposed to this project. While I concur wholeheartedly with Eric Fiddler's comment about how this project is not compatible with the comprehensive plan, I'd like to pick out one of the points that he made in particular and expand on that a little bit. So goal H1 states it is not consistent with the intent for Hopkinton to be characterized by a safe, secure, and attractive residential neighborhood. So this project is not consistent with making Hopkinton characterized by safe and secure neighborhoods. Additionally, section PSF1 of the comp plan starts off by stating that we should maintain a high level of public safety, and not knowing the decommissioning costs or possible future impacts of such a large-scale solar project, I don't think that we can say unequivocally that this is going to help us maintain a high level of public safety. In fact, there are some who are even concerned that such large solar projects, because of the limited funds that have been put forth for decommissioning, may in fact become Superfund sites in the future for cleanup. So again, I'd just like to sum up by saying I am opposed to this project, and thank you for the opportunity to speak this evening.
Thank you.
We now have another member of the public.
Ready?
Carol DeRozier, please state your name for the record after pressing *6, even though I've just said your name.
Carol DeRozier's Pleasant View Drive. I also want to just reiterate that I do not believe that this project falls in line with our comprehensive plan and our rural character for the community. I'm concerned to see any of our commercial property go for things that do not produce jobs in our community. And I think we are putting our community at risk going forward, even as we have seen, although there is a Senate bill out there regarding the taxation of solar fields, we could be even at risk for any future revenue that one might think we could get from solar. And I think so many of us are exhausted from the past few years and getting tired of raising our hand. But so that's why at the last minute, I just wanted to reiterate, I'm still out here and I've been fighting this cause for a long time. Thanks.
Thank you. Okay, looks like we're done. Let's move back to planning board members who graciously deferred their time to the general public. I know we had one request back there a bit. I'd like to return to that. Let's go, planning board members.
This is Carolyn. Joe Moreau and Maggie covered the 500-acre question that I had for Linda Steer, so I have nothing else right now. Thank you.
Okay, very good. Any other planning board members with thoughts or questions?
This is Emily.
Yeah. Go ahead, Emily.
Thanks, Ron.
Yeah.
I had written down in my notes from testimony last time that the contiguous forest was 1,087 acres and that the area to be cleared was 106.1 acres. So for what it's worth, just to add to that discussion. I had a couple questions. One about the Wood Pawcatuck Wild and Scenic Rivers Stewardship Council's letter that was shared with the planning board and the applicant. They had several recommendations itemized in their letter, and I wanted to hear more from the applicant about how those were specifically addressed.
Is the applicant out there?
Yes. Bill, do you have anyone who would like to respond to Emily's questions? Bill, you have to unmute yourself. *6.
He's on his computer.
He's still muted.
Yeah, I know.
Bill, please press *6.
There he goes.
Oh, you muted yourself again. Okay, now you're good.
Okay. Still unmuted?
You're good.
We can hear you now.
Yeah, we can, I'm going to defer to Sergio Cerenzia to address this more concretely, but we had testimony last month by several of our witnesses from Mr. Mason describing, and Mr. Cerenzia describing how the access to that area would be improved, about the great distances from that area, how stormwater is all being designed not to adversely affect that area. Our landscape architect, Ashley Cullion, actually included that area in her viewscape analysis to confirm that people walking the trails in that area, which will now become more accessible as a result of this project and connect to the Narragansett Trail, would not have any adverse view impacts from the solar field based on the topography, on the extensive remaining area of the forest. And the comment has been made that the forest may be, 1,000 feet uninterrupted or undisturbed or contiguous. The point that was made by all of our witnesses last month was that we've tried to accomplish a balance within our project that protects these other conservation interests, which my clients sincerely are concerned about. I mean, we've got 252 acres in this project. Almost 50% of that is going to be preserved as open space. The stone walls will be relocated in some places to help reestablish the Narragansett Trail, an open space and conservation element. And the actual development is only going to take place on somewhere between 70 and 90 acres of the parcel. And it's all installation that could be removed and probably will be removed after the 30 or 40 or whatever the cycle is for these solar facilities to allow the property to be returned. Unlike what could happen under any of the commercial uses that are allowed by right on this lot, where you have septic systems and parking lots and traffic and roads and sidewalks and other things that don't ever get returned to their natural state. So all of the conservation interests, especially the wild and scenic river interest, which is tremendous distance away. I want to say it was, I'm not sure if I'm remembering this correctly, but I'm thinking 900 feet or so away from the closest point. There's nothing happening with respect to that area in relation to this project. Can't be seen, won't be affected by drainage other than the walking trail system now being connected to it from the Narragansett Trail. Now, Sergio may want to add to that. I'm the lawyer, I'm not the engineer, so I would, with the chair's permission, ask if Sergio would like to supplement that in any way.
Sure.
I just want to make sure that I'm clear on what the question is, because there was a reference made to wild and scenic rivers and maybe a list of items. I think Bill has summarized it adequately. I can give you some more definitive numbers where he was estimating, but for the most part, he was correct. But I just want to make sure I'm clear on the question, if you could.
Sure. Yeah, I think I would agree with you both that the testimony, previous testimonies addressed many of the items that were articulated in the letter from the Stewardship Council. You talked about the disturbance within the quarter mile being, within 900 feet is where the disturbance lies of Canonchit Brook. You've, addressed the runoff and the stormwater plans. You've addressed the scenic buffers and the wildlife habitat protection you've spoken to. I guess so I can ask a more targeted and direct question here. There is a recommendation about monitoring the water quality of Canonchit Brook prior to, during, and after construction of the PSES. And so I was just curious if you had any thoughts about that.
I believe we've made representations, and if we haven't in the past, that if our stormwater permit that we obtained through the Rhode Island Department of Environmental Management does not require us to have a testing program subsequent to the construction of the facility, I believe that we've made a commitment to do such if this board so makes it a condition. And I don't think it would be unreasonable to have a testing program for a certain amount of time to ensure that that we're not having an impact. The only issue with that is making sure that it's targeted appropriately. We obviously can't speak for the quality of the water in the Canonchit that is coming from other adjacent parcels. that may be pollutant resources. So we could test the water coming off of our site as a condition of the approval for our stormwater permit and wetlands permit.
Okay. Just for my fellow board members' benefit, I'll just comment on that I think it would be appropriate to monitor the water quality given the proximity to the brook. And I'm sure we could, get recommendations on a water quality monitoring program to assist with that. I had another question about the grading plan and the extent of the grading. If you could speak a little bit to natural features that are going to be preserved, altered, avoided. Basically, I'm concerned about the conformance to the natural topography. What about this site is going to change as a result of the grading?
Sure. When we design and for the constructability of these sites, we don't want to be exporting material out, nor do we want to be importing material in. So generally, we try to follow the contours of the land as is. When solar fields are constructed, typically the topsoil is taken off and stored on site, stockpiled, and appropriate erosion control measures are taken. Some of the areas will be regraded slightly. We're not talking, big cuts and fills on the site. We do have a maximum allowable percentage that the solar fields can be built on, just as a practical matter. But for the most part, we're going to be minimizing the cuts and fills on the site because the constructability and the cost efficiency, it does not make sense to be doing a lot of earth moving, and nor do we really need to, because we've just really, if we could, we would just put the solar field right over the existing land, but we do have to take trees down and then to put in the solar arrays. Once the solar arrays are in, that topsoil goes back down, and then there's a specific seed mixture that will go on it. So to address your comment, we anticipate very little regrading, and the natural topography should remain, with the exception, obviously, of the forest that we need to remove and replace with more of what we would consider a grass meadow or a meadow mix. That also, I will add, has habitat, although it's a different habitat. I think our environmental professionals that are and the landscape professionals that on our team will attest that it does provide habitat and pollinator species that do provide a natural benefit, albeit it's not trees. We acknowledge that, but it's a different type of stabilization and vegetation that will grow underneath these solar panels. The solar panels, with respect to with regard to surface runoff, are not considered impervious. Obviously, the panels are an impervious surface, but by virtue of the fact that the water runs off of them and onto the ground below, it allows that water to seep into the ground as long as it doesn't exceed a certain percentage. In cases where it does exceed a certain percentage, low to moderate, I believe, is somewhere between 5 and 10%, 10% to 15% and over are steep slopes. We make sure that we stabilize the site appropriately. We capture that stormwater and we send it to stormwater facilities in the forms of infiltration basins, so that water does get put mostly back into the ground and grab back into the soils, and then is attenuated appropriately and metered out accordingly, so that it doesn't impact the wetlands and the brook down gradient.
It's actually a perfect segue into my final question, and then I'll hand it over to other board members. And my question is actually for a representative from Crossman Engineering, if they're on. And I'll just say my question, then we can figure out if they can answer it. In their assessment that was provided to us, they talked about the topography of the site and the orientation of the panels being, just try to be objective as possible, less than ideal in terms of impacts for erosion, because the panels are oriented 90 degrees to the slope. Some additional measures, they saw the need for additional measures to control runoff and erosion, since the land is it's not sloped the way that you would hope it would be when you orient panels for a solar installation of this size. So I'm trying to get a sense of what is the plan that you have all put forth and revised according to Crossman concerns. Does it address that? How big of a problem could this be? Water movement, a lot of folks in the public comment have brought up the fact that forests are sponges, and when you remove forests, there's a lot of extra water that is not going to be absorbed by a natural system. So we're talking about lots of water that could be deposited on this site. And I know there are these retention ponds and stuff that are basically a ring around this. It's a disconnected ring, but the site is kind of, a sloped feature where all of these wetlands and detention ponds are surrounding it. I'm a little bit concerned about the amount of potential runoff and this disconnection of the land from the wetlands, which are part of the land. So I understand that stormwater retention ponds will capture water, but will those stormwater retention ponds prevent water from getting into the wetlands that are right nearby that, I know we're trying to prevent pollutants and other things that come in runoff from getting into the wetlands, but are we going to have a wetland disconnection problem because we've got all these stormwater detention ponds and so much water not being captured by forests? I'm concerned about the connectivity of the site and because of the scale and the alteration of the natural system.
Emily, it's Maggie Hogan here. I see Steve Cabral on the screen. I think he probably can answer those questions.
Perfect.
For you.
Oh, yes. Oh, good evening. I'm Steve Cabral with Crossman Engineering. And those concerns are certainly very good ones that we looked into in extreme detail. Now, at the master plan stage, in the checklist for the town, it does require detailed drainage data. But in this application, they're seeking a waiver to provide the detailed drainage analysis at the preliminary stage. And so as of today, we've only received conceptual drainage data and conceptual drainage sizing to demonstrate that their intent is to fully conform to all of the town and state stormwater standards. And you're correct. One of our concerns that we've had with solar fields where the orientation is such that the panels are perpendicular to the slope is that as precipitation cascades off of the panels, they don't have the opportunity of forming a sheet flow, which is the intent of the stormwater on solar panels. What happens if the solar panels are oriented perpendicular to the slope, you end up having this cascading flow forming a channel. So immediately you have a potential source of erosion as the runoff flows down the slopes. So once the designer provides the detailed drainage design, what we would look for is to make sure that they incorporate measures that would take that cascading flow and make sure that it gets distributed in a manner to recreate the sheet flow so that it could flow through the grassed hillside, in a manner that doesn't create erosion. And one of those options would be to install periodic stone channels parallel to the contours. And what that would do is that would take the flow cascading off of the panels. It would flow into these stone trenches, and then the stone trenches would be sized in a manner that the flow would be able to spread out and sheet flow down the hillside. Another one of our concerns with solar farms is that we've noticed that during the construction, the ground tends to be compacted much more than the designer anticipates. And once the soil gets compacted, the runoff from the solar fields is significantly higher than the design anticipates. Now, because we were at master plan stage, we're able to make sure that the design incorporates the additional flow. When it comes to a disconnect from the wetlands, basically the design is intended, or the standards are intended to make sure that the pre-existing hydrologic balance is maintained, meaning we'll make sure that the volume of precipitation that infiltrates is similar under proposed conditions, and that the volume that discharges overland directly into the wetland is similar to existing conditions. So we will be looking at the potential for erosion, and therefore we'll be looking at additional measures such as those stone channels, and we'll be making sure that the infiltration ponds are sized to make sure that they do mimic the existing hydrologic conditions. And one related concern that we had with the landscape architect's presentation is that they had referred to bioretention systems. And one reason that was a concern is that the conceptual drainage design was based upon infiltration ponds. And there is a significant difference in the performance of a bioswale or a bioretention pond and an infiltration pond. And that primary difference is that the biofiltration systems rely upon the precipitation filtering through organic soils, as opposed to an infiltration pond that relies upon the precipitation infiltrating through the natural, say, gravelly soil. So the infiltration ponds have a much higher infiltration capacity than the biosystems. So when we do get into the preliminary stage, we're going to make sure that the design is coordinated appropriately between the landscape architect and the engineer. So I hope I answered your question. Oh, and one other thing I'd like to point out is over the past couple of years, as everyone has pointed out, there's been a considerable amount of construction of solar fields in Hopkinton. And we found that some of the DEM regulations and standards really don't address all of the issues related to solar panels, solar farms. So we've actually introduced DEM to some of the sites in Hopkinton, and we've made them aware of site-specific issues that do arise and how these site-specific concerns aren't necessarily reflected or addressed in the DEM standards. And one of the outcomes is that DEM is in the process of publishing new standards for stormwater runoff from solar fields. And I believe that Sergio Fiorenza has indicated in past discussions that he's willing to incorporate those new standards, even though they're not in effect as of today.
Thank you. That was really helpful. How unusual is it to have this stormwater waiver at this stage? I mean, given what we would like to know, some of the questions that have been raised and some of the issues, is that critical information that we really should have in hand when making a decision about this master plan stage?
Okay, typically the major land development process, as you know, has 4 stages: the pre-application, master plan, preliminary, and final. And the underlying intent of the master plan is really to establish the concepts, not necessarily the final details of the design. There just seems to be a disconnect between the checklist for the master plan in Hopkinton that has a notation that requests detailed design versus the general concept of what master plan is intended to do. And this differs from the development plan review application, which would normally require the applicant to submit all of the full-blown design at once.
Okay, thanks.
Emily, you good with that?
I'm good. Those are all my questions. Thanks.
So Al Diorio, Steve, if you're still there, I'd like to just follow up on Emily's thought process, specifically with regards to this, the applicant's request for a waiver concerning this topic. I get that the master plan is not the definitive design, but I guess I'm I'm asking you your opinion. Is the granting of the waiver, does it put us in a bind if we approve a master plan with this waiver, and then the applicant finds out that certain things can't be supported when they get down to the brass tacks? I mean, does it simply mean that the design changes to accommodate the final calculations?
Yeah, basically, what will occur is that my honest opinion is that due to the steep and rolling terrain of this site and the fact that the infiltration ponds are being built in areas that are sloping, I do anticipate that as the final design progresses in the preliminary stages, that we will find that the stormwater mitigation system will require more land area, and therefore the footprint available for the solar fields may actually decrease. Now, as an engineer, I'm guilty of, I like to follow checklists, and I love to analyze numbers. So when it comes to granting a waiver from a checklist item, it's always been my opinion that a waiver should only be granted if there's a true hardship or reason for granting that waiver. But I also understand that in general, the purpose of a master plan is really to iron out the concepts. And I have heard the applicant's engineer testify that his intent is to fully conform to all of the stormwater requirements of the state and the town. So that concept I would accept, because as we go to the final stages, I could only approve or give a positive recommendation if all of the standards are met. But without those detailed computations, which are required on the master plan checklist, I cannot testify, or no one can testify, that the footprint of the solar fields will or will not change. So I may not have answered your question.
Well, I may not have posed it properly.
Okay.
So, and that, my apologies for that. So again, my takeaway is we have a concept before us. If we grant the waiver and we accept this as a master plan, when we get down to brass tacks, if things need to change, they will change because the applicant has to comply with certain standards. Would that be a fair statement?
Yes, and it's my understanding that if the stormwater system has to be enlarged above and beyond what's depicted conceptually, that doesn't grant the applicant the ability to make the solar farm larger. If anything, it's my understanding they would have to make it smaller to accommodate the stormwater standards.
I understand. I think I have my answer, and I appreciate it. Thank you. So any other planning board members? We are in excess of our timeline, but that shouldn't get in the way of asking questions and getting answers. Planning board members.
Yeah, this is Ron.
Comments. Sorry, I'm good.
I'm sorry.
Thank you, Emily.
Go ahead, Keith. Go ahead, Keith.
No, I'm just satisfied with the public opinion. And Emily, thank you always for being on point with so many questions that are on the tip of my tongue, but you execute them very well.
So very good. Ron, did you have some questions?
I did. First of all, I'd like to compliment the people in the audience that spoke up with their heartfelt feelings. I feel the same way. As we've stated before, I've been in this town going on 70 years. It's a 7 and a 0, not a 1 and a 7. And that has a lot to do with the way that I think. Now, my first question would be for Jim, the applicant. The proposal is to be put or suggested to be put on commercial property. Is that correct?
Jim Lampier, town planner. Ron, that is correct. It's commercial special is the zoning.
Okay, the next question. Has the applicant followed the checklist and followed the guidelines set forth by you and the town.
Yes, I certified the application complete.
Okay, thank you, that's it.
Okay, any other planning board members? I'm sorry, go ahead.
I was just gonna say I'm finished.
Okay, great, thanks.
You're welcome.
Mr. Chairman,
Yes,
it's Maggie Hogan.
yes.
So we had a topic from last month that I raised and we haven't addressed, and that is whether or not the planning board will take a site visit to this property to see this firsthand on the ground. It's one thing to see an application on paper and in documents and on a screen, but there's a whole other ball game when you walk the site and you can see. There were his testimony tonight from an abutter that talked about what would be seen on his property, and I don't think that the board can fully make findings, perhaps in a project this large without undertaking such a walk. Now, I know with COVID, it's been a, kind of a crazy time for this type of situation, but I think maybe it's worth a conversation to see whether that can be fit in, prior to closing the public hearing and making a determination on the application.
Maggie, thank you for bringing that up. I know that I personally would benefit from that kind of site inspection. I was thinking about how I was going to respond to Mr. Gregory's invitation to visit his site. And while I'm not sure that's entirely appropriate, perhaps that could be accomplished by a site inspection of the surrounding area, that is the applicant's site. So my personal take on that would be, yes, I would be very interested in it. I don't know how other planning board members feel, but this would be your opportunity to chime in.
Yeah, this is Ron. I would be very interested in doing that, taking the sidewalk.
This is Emily, same.
I concur, Carolyn. I concur.
Yep, he's here too. If it's beneficial to the process, I'll be part of it.
Okay,
let's
so
go
the
for a
next
walk.
thing you would want to do, Al, is to try and find a date that worked for the board and the applicant. Now, a couple of things that go along with this is the meeting is considered a public meeting. It does have to be advertised and noticed. It's the applicant has to make a determination whether members of the public will be permitted on the property. And if not, then we'd have to come up with some kind of not streaming, but a recording mechanism, if you will. I would also caution the board members that basically it's a one-way flow, primarily of information. It's not a back and forth. You're not to discuss the application or the merits or the details of it amongst yourselves or with members of the public if they're there. You're there to absorb information. So basically someone from the applicant, I assume Mr. Sherenzia or someone from his team would be saying to you, okay, look at your site map. Here's where we are. That's north, that's south. This is what we're looking at, orient you, that kind of a thing. So you're there as observers. You're not there to, engage in an analysis, if you will, of the project. So I just wanted to give those cautions right up front so everybody knew what the parameters were when you go out there. And we do have to have the minutes, recorded from that meeting. So Talia or somebody would need to be there to, take down the notes.
So I appreciate that guidance. I do have to inquire, however. I've conducted a number of these in the past. I don't think I'm a stranger to it. So when we do a site inspection, I'm not a big advocate of being a mute as I walk around. There are things that I'm going to want to know about. if the public is invited and cares to join us, there are things that they're going to want to know about. Now, it's a public meeting.
Yes.
If we're all standing in a circle, I don't see why we can't have a discussion. So if I'm mistaken or misaligned, straighten me out.
So you can't be having discussions amongst yourselves.
Oh, like off to the side.
Yeah, you can't
Oh, I
be standing
understand.
next to a member and being saying, well,
Yeah,
what, do you see that over there? You know,
Yeah, no, I understand.
you can ask the Mr. Sherenzia or a member of his team a specific question. You know, is this where the detention pond is going to be, et cetera. But
Yes.
the better part of Valor is to let them do most of the talking and the explaining as to where you are.
Understood, understood. So as long as everything is out in the open, that's the intent of a
Yes.
public meeting, we should be okay.
Yes.
Okay,
And that's
So-
assuming, of course, that the applicant is amenable to
yes. Yeah,
having
we
a
haven't-
public meeting on the site.
Yep, we haven't quite gotten that far. Good.
Yep.
Okay, so now let's ask that question. It sounds like, and I'm directing this to the applicant, it sounds like there's enough interest from the planning board to conduct such a site inspection. So first of all, are you amenable?
Yes, you can hear me, Mr. Chair. This is Bill
Yep.
Landry. I'm absolutely certain that my client is amenable to a site visit for the members of the planning board. I mean, we've got an awful lot of individuals who are interested. It may become a little bit unwieldy to have an orderly process. I mean, my experience at these things is that the purpose, sort of like a view that's taken by a judge, is to point out what people are looking at so that they can orient themselves to the site plan and other information that they've heard, as opposed to, well, how are you going to handle this, or whatever, some more substantive things. So I really, and this is one of the drawbacks of COVID and these virtual meetings, that I don't really get a chance to confer with my client in any meaningful way on new things that come up. So I'd like to have the opportunity to do that. It's not my land. It's not my liability. I really would like to confer with my client as to whether they're open to having a public meeting that could draw, I mean, who knows, 60, 70, 80, I don't know how many people are going to want to become part of this. And can we really do that in a way that's, that's safe? I've walked the site in the snow, and there were a lot of ups and downs and steep climbs, not dangerous climbs, but aggressive climbs, changing elevations. We've heard about that. It may not be for everybody. And I think we've got to, be prudent about how this is handled. It may be best, since the public, will not have the ability to interact and ask questions. It might be better if this is a videotaped, well videotaped and choreographed operation, so that people can really become familiar with the site. Make sure that whoever is taking the video is panning the entire area, and we can see on National Geographic how well that can be done in much larger areas than this. That's where my recommendation is leaning. But if someone on the board felt very strongly otherwise, that direction is not appropriate, my client's about 100 out of 100 so far in agreeing to whatever people from the town really want him to do.
Mr. Landry, if I could suggest, it's Maggie Hogan, if I could suggest the option of the planning board members going on this visit with someone there to film that and to film what you're talking about, that probably satisfies both elements of what we're talking about. But for the decision makers, and the
Yes.
members of the public are not the decision makers. So the decision makers here, and this is a major project, and there's a lot of responsibility here. I believe that the board is going to be well served by personally visiting the site and seeing what it is that we're actually dealing with.
Oh, absolutely. That's a given. My
Okay,
comments assume that the board and the stenographer, anyone
Okay.
officially associated with this process would absolutely be there in person.
Excellent, thanks.
Yep, very good. So Al DiOrio. So Bill and Maggie, I think that's a great direction. Planning board members, and I don't know how we orchestrate someone taking video here, but something that the public can then view to see what the planning board saw would be great, because just a quick story, I was on a site inspection planning board in Richmond, and it was a small site, but it was rugged. And one of the planning board members took a digger and was injured, and it was
dear.
not a good thing. So I can only envision on a significant site like this, with significant relief and maybe some obstacles, as much as the public might want to participate, it just might not be in everybody's best interest. So I'm in favor of that approach.
Yes, Mr. Chairman, Jim Lampier, Town Planner. I have a question for Solicitor Hogan. Maggie, if the planning board members were to go out on the site and instructed not to talk among themselves, but to listen to a presentation by the applicant and have individual planning board members ask questions of the applicant's representatives one-on-one with the answers going back and forth, does this have to be a public meeting? And what is the necessity of videotaping this? Because I can just see now, all right, now we're going out there videotaping something. We're going to have a meeting here, I guess, and we're going to show the video to the public. I mean, this meeting, as I see it, is for the information of the decision makers, the planning board. So, I mean, I'm just wondering when we're going to get to a conclusion of this whole process.
Well, so while I understand the desire to conclude a matter, that can't override the necessity for being thorough and undertaking what needs to be undertaken. So for purposes of transparency, if you will, it's a public meeting, yes, and for purposes of open meetings, which means that the board has to post it. We have to follow all the open meeting requirements. That includes, under the current pandemic guidelines, which are a little bit different than previously, that when you have a public meeting, that there be a public manner for the public to participate. And the only way physically to do that in a safe manner is, I believe, is the manner which I've suggested, unless somebody else has a suggestion as to how to accomplish that. Without the pandemic virtual meeting guidelines, I would have said previously that the public is not entitled to go on that site visit, even though it is a meeting of the public entity, because the landowner has rights to exclude members of the public from their property for liability reasons. And Mr. DiOrio has just highlighted the perfect example why. Someone can get hurt.
Okay. So it sounds like the planning board members are interested in a site visit. It sounds like the applicant is amenable to same. Can we target a date? And Bill, I don't know if you just need to go back to your client and ask them if this is going to be okay, but if we could nail down a calendar, that would be very helpful moving forward.
Yeah, I think I'm sufficiently comfortable. Just check my messages here. Yeah, I'm sure we can get an insurance certificate and work those things out. The preference was for the board members only, but I don't have anything beyond that. So I'm going to ask my clients who are listening to listen for the suggested dates or availability dates that the board prefers and see if we have any showstoppers amongst those dates. That makes sense.
Phil, while you're doing that, could you give us an idea, or maybe Sergio Sorrento could give us an idea? I know the site's quite large. Give us an estimate as to what sort of time frame it would take to undertake this visit. 2 hours, 3 hours, what are we looking at?
I would give it 2 hours and invite Sergio. That may be a little bit too much, but if people are stopping and observing and asking questions about particular areas, who knows? But I'd say at least 2 hours.
Okay.
But Sergio's intimately familiar with the pertinent details. I mean, if we're going to go over to the Canachet Brook and the wild and scenic rivers area and start looking and taking perspectives, it could be closer to 3 hours, actually.
The longest walk that we took out there with the Conservation Commission chair, Harvey Buford, and the Appalachian Mountain Club probably lasted about 3 hours, but that was a lot of stopping, talking, looking at different historic relics on the site. It all depends on how much this commission wants to see. I can definitely navigate the site, and we can come up with a strategy beforehand, and then we can. But I think Bill's right on. It's going to be at least. I would budget at least a couple hours, if not more.
Okay, great. That's what we need to know.
Yeah, Sergio, that's a good point. My thought process here would be planning board members would submit in advance some topics or areas of concern, and we focus on those. So I'm not suggesting we're running through the site, but there's a time limit here. I know that I would not want to be out here for 3 or 4 hours. I want to see what I feel is important, and then we move on.
And also, I would, if there's anything that needs to be staked in advance, that are particular features that you're concerned with, please let me know so that we can get the appropriate survey markers out onto the site.
Yeah, I would speak to that. Sergio, I don't really think we need to bring it up to that point. I think it's important that someone like yourself is there so that if someone needs to know where, say, a stormwater basin is going to be located, and you want to wave your hands and say, well, it's going to be approximately in this area, that's probably going to be good enough. I don't think we have to start imposing survey work on the applicant. That would be my opinion.
Thank you. I appreciate that, Al. And there are a number of features on the site which we can point to that will orient us, including a significant amount of test holes in those said stormwater areas. So I feel very confident and comfortable we can navigate the site with the things that are already out there.
Outstanding. Let's get down to calendar. Planning board members' preferences. Targeting 2 hours.
This is Ron. I've stated before that I'm retired. I have plenty of time, so whatever works for everybody else will work for me.
Outstanding. Ron, I'm not retired, so not every time will work for me. I'd like to recommend perhaps a late afternoon. And
I guess the ball's in your court.
I'd be reluctant to start recommending anything on the weekends, only out of respect for my colleagues.
This is Emily. I'd be in favor of, we're not working against daylight right now, right? Which is great. So 5 p.m. to 7 p.m. or something on a weeknight would be fine, as long as it's after 5 p.m.
Okay. Al Diorio, I personally like that one.
I do too, Keith here.
I'm going to throw a date out there for you then to see if it works for folks. What about next Tuesday, the 25th, if that's not too soon?
Not good for me, Diorio.
Okay. Then we're approaching the holiday weekend at the end of the week. So that's going to be a problem for probably most folks. The following week would be Tuesday the 1st. It's the night before our next meeting.
Tuesday the 1st is good for me, Diorio.
Yeah, Tuesday the 1st works for me. This is Ron.
We have a problem with Tuesday, the 1st. That's not,
Okay,
it's not gonna work.
right. All right, well, the next night is already taken by the board. We're already regularly scheduled for that evening. And I don't think we want to give up, Jim, I don't think we want to give up a whole night of hearing due to the site walk, correct?
Correct, Maggie.
Right. Okay, so let's keep going on then. The 3rd would be the night after our meeting.
3rd is good for me, Diorio.
This is Ron. 3rd is fine for me.
Works for me too.
Carolyn here, the 3rd works for me.
Yeah.
Keith and John?
Yeah, Keith here. Thursday, 3rd is fine for me.
This is John. I cannot do the 3rd, but go on without me.
Sounds like there's a consensus on the 3rd.
Okay, so the only thing I would say is that if for some reason a board member can't make another hearing, John's our alternate and he would have to step in, and now he's missed a meeting. So if we can find a date that works for everyone, that probably would be best under the circumstances.
Okay, then we should continue with our calendar.
Yes.
So and before we get there, let me just interject. So we've already gone by our meeting of the 2nd, and now
Yes.
we're rapidly approaching our meeting of the 16th,
Mhm.
which I also believe is our timeline on this project. So listen, I'm prepared to just keep going on the calendar, but at some point, something has to give.
Right.
Mr. Landry,
understand.
I'm speaking to you. So,
That's
Mr.
fine.
is Ron. I have a
I
question.
know where you're going, Mr. Durio. There'll be no issue with that.
Okay, very good. So we can continue with our calendar, appreciating the fact that we're not going to be held to what I believe is the 16th.
Correct.
Okay, very good. Thank you.
How does
Mr.
Tuesday
Chairman, I
the
have a
8th?
question.
Sorry. Go ahead, Ron.
We have completely ignored the 26th, 27th, and 28th of May.
Yeah.
I'm curious why we did that. We talked about the 25th, then we jumped right to the next Tuesday after that.
Yeah, I
Well,
think
but-
I'm just curious.
in Maggie's suggestion, she felt then I can't help but agree that we're moving in on a holiday. Well, I mean, we can talk about it, but folks have
I
plans
will
for
not be
holiday.
present. I'm leaving town first thing on the morning of the 27th. I will not be available.
And so there's our reason.
Okay,
It's a
thank
holiday
you.
weekend.
Yeah, I'm perfectly okay with moving away from the holiday. So we left off.
How about
on-
Tuesday, June 8th? Let's take a look at that.
Yep, Diorio, good for me.
That's no good for me. My wife and I are election supervisors, and I am committed to the town hall till 9 o'clock at night.
Okay.
Thursday, the 10th.
That's no good for me either. The 10th through the 20th is no good for me.
Oh,
Oh, boy. Okay.
I have property closings in May that I have to attend.
understood. I jumped over the 9th. Is the 9th good for folks?
What
The
day?
9th is fine for me.
This is Talia. Can you each say one at a time if the 9th is good for you? Because it's sometimes people will come in at the same time as other people. So
Sorry, Keith there. What day of the week is that?
The Wednesday.
That would be fine with me. Keith there again.
This is Carolyn. I'm okay with the 9th.
This is Emily. That works for me too.
This is Ron. The 9th is fine with me.
Okay.
How about John?
It's good. This is John.
All right, looks like we have a date.
Okay.
And we can get the,
check with the,
we'll
did
get
we
the
check with the
details,
applicant to make sure that?
get the
It's
details
fine.
of where to meet and what time. So that's administrative.
I think we said 5 o'clock. Does that work for everybody?
Will there be hot dogs?
Yes.
Keith asked if there will be hot dogs.
Oh, hot dogs. No, I can't guarantee that.
Okay.
Bring my own.
5 o'clock.
All right, very good.
Meeting place?
There's an entrance, not sure, I think we may have a poll number. There's an entrance off of there are two Palmer circles. The second Palmer circle entrance, the second of the two Palmer circle roadways after the exit. The second one has a well-cleared, well-defined entrance onto the site that was used for the meetings with the Conservation Commission. And there is an ability to park along there and even on the grass. So we could, at maybe Sergio can chime in. I think we had some poll numbers for that that entrance there, but it will be very, very obvious. We'll put some cones, red cones there, and maybe have somebody there to flag people in. But it's almost toward the end of the second Palmer Circle entrance. After crossing the highway, comes up very, very quickly after crossing the highway. We could provide directions for the board, but unless someone on our team or one of our consultants has another opinion, that's probably the best place for us to meet.
That is the best, and that is the best place, and it's National Grid poll number 26.
Okay, so I think we could leave the details of that component of things for the applicant and the planning department to work out and get that information out to everyone. Because we're now burning the midnight oil here and we have another applicant that we need to get to.
Mr. Chairman, Jim Lampier, Town Planner. Maggie, I have another question for you.
Sure.
Do we have to continue this public informational meeting to a date certain, or should we close it?
You should not close it. You should not close it because you're probably going to, you may want to discuss what you've seen on site when you come back. You may have additional questions that you want to ask in the public arena, as a result of that site visit. So you should not.
Okay. So do we want to continue this tonight to a date certain of June the 16th?
I would think so.
Oh, okay.
I would agree.
Mr. Chairman, if you are considering a date certain, I would just note that our office is jammed up on the 16th. So if it's all right with the applicant, I'd ask if we could go a little bit further out than that.
Well, the next regular meeting would be July the 7th. And we have Skunk Hill coming back then.
We would extend, unless you want to extend it continue it to the meeting that's going to take place on June 9th. And then further continue it after that. We'll extend the time for the board to act on the application, certainly through, another 30 days from the current June 16th date out to, maybe July 19th or something like that, to make sure we have a couple of planning board opportunities. But I'm not sure why we couldn't just continue this process to the site visit meeting.
Because the public's not going to be there.
Right, then we'd have to do another continuance.
So I would suggest that the public information meeting be continued to a date certain so that there's no renoticing stuff. And with the understanding that we will be conducting the board will be conducting a site visit in the interim, and will provide that information to the public thereafter. But, you know, because the public isn't going to be attending that, I'm a little concerned about using that as the date certain.
No, I understand that. So look, can I just suggest that we make it then to the July 7th meeting? And we would extend the time for the board to act until, you know, maybe July 21st, with the same understanding we've had that if, you know, we're all making progress in good faith, it would be our intention to continue that period for the board to act further that time.
Jim Lampier, town planner. I just want to mention that we're in a grace period right now where we have 2 meetings in May and 2 meetings in June. It's my understanding that the board wants to go back to 1 meeting a month. So I would suggest, Mr. Landry, that you give an extension of the decision period through the August meeting, first meeting in August. I don't have that date in front of me, but.
The August 4th.
Okay, through the August 4th meeting.
Okay, that's fine.
So that's the decision period. And then, so now we're going to continue the public informational meeting to July 7th. Okay,
That's fine.
that works.
Okay, so then I would entertain a motion for the continuance.
This is Emily. I'll make a motion to continue the public informational hearing on the Stone Ridge application.
This is Talia. Meeting, not hearing, meeting. Sorry.
Public informational meeting. Sorry. So I'll make a motion to extend the date for the public informational meeting for the Stone Ridge at Hopkinton application until July 7th. Is that what we said? And extend the decision period for the planning board until August 4th.
Very good. I have a motion.
I'll second. This is Ron.
I have a second. Any further discussion? All in favor? Diorio, yes.
Grellwitz, yes.
Lindelo, yes.
Light, yes.
Shamshina, yes.
Okay, very good. Thank you. Okay, before we move on to the next order of business, I do want to mention again, for those that might have been joining us late, that earlier in the meeting, there was a revision to the agenda. The application for the master plan public informational meeting for major land development Skunk Hill Road Solar has been continued. So if you're in the audience awaiting action on this, you can stand down and join us next time around. So the next item under new business, I will be recusing myself on this application as I have in the past. My firm has performed surveying services for this particular applicant. Although I am in no way associated with this project, I would ask Ron to take the helm here for the remainder of the meeting. Handing my recusal to the clerk.
This is Talia. I am receiving Mr. Diorio's recusal form.
Okay, moving right along. Do we have the applicant and/or attorney for Centrica Business Solutions present?
Joelle is here.
Okay. Attorney Joelle, please continue.
I'm just making her a panelist, so I think she's going to be.
Okay.
All right.
Thank you. Can everyone hear me?
Yes.
Yes.
Great. Good evening. Joelle Rocha, attorney for the applicant and owner tonight. I'm not sure if there's any housekeeping before I start, or we'll dive right in. I know there was we did submit a memo per your request last month.
Yep. We received that. Thank you. And any further discussion on that, Mr. Prowitz?
I had no discussion. I think we're ready to proceed. The planning board members, do you have any discussion on the memo or anything pertaining to it? I'm hearing nothing.
Carolyn, I'm all set.
This is Emily. I think just for the public's benefit, we received the memo and we've received guidance from our planning solicitor on interpreting that memo. And the recommendation we've received is that there's essentially no impediment to our authority to hear the application and decide it on its merits. So, I'm sorry?
I'm sorry, I'm just jumping into a new computer and it's echoing. Just give me 1 second.
Oh, sure.
Okay, it sounds like we're ready to proceed.
I think we were going to wait a second, Ron, I didn't know if Maggie had anything to add to that statement.
Oh, okay. Okay. I thought that was her voice. It's my mistake. I apologize.
Nope, no problem.
Sorry, that's my alarm.
I don't know,
Are we
Ron,
still
if you
waiting?
want to, yeah, I don't know, Ron, if you want to see if Maggie is still.
This is
getting
Talia.
back.
Maggie is still not, she still hasn't rejoined the meeting yet.
I guess she really has to be here to hear whatever Attorney Rocha has to say. Let's give her another couple of minutes. Is there some way that we could ring her doorbell? Maybe her phone's gone dead or something.
This is Talia. I think that she was changing from one computer to another because the
Okay.
first computer she was using might have died. I think that that's what she said before she cut out.
Okay, we'll give her a little bit of time then.
Here she is. Promoted to panelist. Back in the saddle again.
Okay. Attorney Hogan, you are present. Maybe not.
Yep.
Yeah, you're not going to be able to see me. I apologize. I'm on my third laptop here. But I'm here.
This is Talia. I can confirm.
Very good then. Attorney Rocha, you may proceed.
Thank you.
You're welcome.
As this board is aware, the town council allowed for the zone change at this property from RFR to commercial special to allow only solar at the property as a use. The town council also set 17 detailed conditions, many of which govern the design of this project. The town council, as it was required to under the statute, found that the zone change and the solar use itself was consistent with the comprehensive plan, citing 2 specific sections. The town council also amended, as you all know, the comprehensive plan's future land use map to allow solar at this site. We were before this board on pre-application, and we've incorporated and hopefully addressed some of your comments from that meeting. We've also had site visits with the Conservation Commission and the Land Trust. As the planning board is aware, several of those conditions of the zone change related to the land trust itself. First, if the project's approved, the land trust will have a conservation easement in an area outside the fence and the limit of disturbance. The zoning ordinance also calls for the land trust to have a conservation easement across the whole property after decommissioning. To that end, another condition provides for us to work with the land trust on a reforestation plan. We've had some great conversations with the land trust over the last several weeks. We are thankful for the continuance you allowed us in April to allow us to further those conversations. And we've agreed to the terms of those, of that future document, fingers crossed, should the project move forward and be approved. We've looped in the land trust attorney who's prepared, if we get to that point, to draft up the conservation easement under those terms. One change we did have, and you probably will hear from the land trust, if not tonight, at a future time on this project when there is public comment, so I don't want to speak for them, I just want to update the board. But actually, we found it better for all parties that after decommissioning of this project, the property will be deeded, Unit 2 will be deeded to the land trust. So it's important as this project hopefully moves forward that the future decommissioning, reforestation, or whatever this property looks like in the future, that it's in partnership with the land trust, and we're fully on board with that. At this point, I'll turn it over to our project engineer, Jason Gold, to go through the proposed conceptual site plan. As the board knows, we're at the master plan's concept level and have a lot of work ahead of us after this stage with respect to DEM approvals, a process which we've already begun, as you'll hear from Mr. Gold and as probably noted in our packets. And then the detailed engineering and stormwater and landscape and what the property looks like after decommissioning. So we're fully aware we need to do all that before we see you again. You'll see we've submitted for the board's consideration and addressing comments from pre-app that we've set the array back 100 feet from the neighboring residential property. We will discuss that in more detail momentarily. There is one addition, since I've had the benefit of sitting through previous solar applications the last couple of months. Member Light had asked on the previous application about the interconnection status, so I just wanted to get that out of the way on this. There was a reference on the previous project that they had to go through a study. We actually got our interconnection approval in 2019 on this project, so our study was complete in 2019. So we're not held up in the queue on this project, which will allow it to go forward if we get the approvals. So unless there are any preliminary questions for me, I'll leave it to the professional to go through the site plan with you.
Okay, thank you. Mr. Gold, are you ready?
Mr. Gold, this is Talia. Please press *6.
Yep, I am unmuted. Will I be able to share my screen?
Yes, let me just elevate you to participants, to panelist status. 1 second.
I may have to upgrade from a flip phone.
Okay, thank you. I will, looks like I'm a participant now. I'll share my screen.
Okay, thank you.
And just let me know when you can see that.
This is Talia. We can see it.
All right, great. So as my name is Jason Golden, civil engineer with ESS Group. As Joelle just mentioned, we've advanced the design quite a bit since you saw the concept at preliminary in January. So what I'd like to do is just give you a brief overview of some of the changes that we've made. And then, of course, I'm always happy to answer questions. So in general, we've incorporated feedback from the board during the pre-app, discussions with the town planner, and also some preliminary discussions with the fire chief. Those include some advanced designs to the driveway, the stormwater design, grading, proposed ground cover, and increasing the eastern setback. Now, we've also reduced the fence area quite a bit to accommodate those changes. So this sheet, for anyone that's not able to view online, is drawing SO1, which is sheet 3, showing the new array layout. Some of the changes that I want to point out are the eastern setback. We were requested at the pre-app to look into increasing the setback to the array by to 100 feet from the property line. And so we've pulled that in. Now that's now 100 feet between the array and that eastern property line. In doing so, that also reduced the fence area. It was originally 9.07 acres. It's been reduced to 8.1 acres. And that also reduced the size of the array a bit by a little more than 1,000 panels from 8,764 to about 7,758. I do want to point out that even though the array changed a bit, it does not affect the profile views that we showed you during preliminary application. I'm sorry, during the pre-app. Those views were from Chase Hill Road and from Polycoon Bridge, showing that the topography blocks the views from those locations. The changes to this layout does not affect that at all. So those figures are still valid. Moving on to the landscape plan, drawing C1. We have prepared this to show more detail of the ground cover that was not available during pre-app. We're showing a low growing grass inside the fence beneath the array, a restoration mix outside of the fence, and a restoration mix intended for detention basins within the detention basin. This plan also shows where the gate location is. There was some confusion, I think, about that during the pre-app because it wasn't labeled on the plan. So this does show the gate location is right in here on unit 2. There was some question about which unit the gate was on during pre-app. So the gate's right here on unit 2. And that will be locked with a Knox padlock to provide fire department access to the gate if needed. And the driveway width has been revised a bit, or at least the design has been advanced. So it's a 15-foot road, which it was during pre-app. And we are also narrowing it down to about 12 feet where we cross the wetlands. And then it opens back up to 15 feet again. And we've done some grading as well. This is on drawing C2. There's not a lot of grading shown. We try to maintain the existing topography as much as possible. The majority of the grading is on the road to minimize those slopes coming down that hill, and then for the detention basin. So we do have a stormwater design here. The stormwater detention basin, it's actually very shallow. Since most of this area is already grass, there's not a lot of change happening in this area. So it's about a foot deep stormwater detention basin that just spills over on the land. It's nothing, nothing too obtrusive. So that is that's the bulk of the changes. Future work that would be done for preliminary review would be the noise study, the decommission plan, the soil erosion sediment control plan, Rhode Island DEM, wetlands permitting, which we have started. We've submitted a preliminary determination application to Rhode Island DEM, and they have reviewed it and issued comments. And so that process is ongoing. I am happy to take any questions.
Okay, thank you. Planning board members, any questions? I'm hearing none. Okay, Attorney Roca. Oh, go ahead, Emily, I'm sorry.
Hey, Ron. Yeah, I've got a question. It actually is a little bit more general, doesn't necessarily relate to the specific design plan shown here. The discussion about the agreement with the land trust about the status of the site after decommissioning, that, you know, it's the applicant's their intention to deed this site to the land trust. I was curious if a specific decommissioning date is being considered or articulated or named in this agreement, or if it's just, you know, decommissioning as to be determined by the applicant at the time appropriate by the applicant, or is it, you know, 30 years from the day that the switch is turned on, that's decommissioning?
We haven't gotten to that level of detail yet. I think everybody's sort of in a holding pattern to see if this moves forward. I know the land trust didn't want to fund the legal expense, and I don't blame them if it's not going forward. I suspect that it's going to be decommissioning in the broader sense, rather than a time frame. I think you're probably looking at that period anyway. But I think, I don't know how it'll be defined yet, so I can't answer that question, and I apologize. But that level of detail will be in that agreement for sure.
Okay, thanks.
Anyone else?
This is John. I have a question, and it's I believe I asked this in a previous meeting regarding access to the third condominium unit. It's unclear to me if that is a requirement because it's the same owner, but we're not allowed to create non-buildable lots. Who can offer some clarity on whether or not that third lot can be isolated?
Sure. So it's actually a different owner than unit 2. So the condominium documents as they stand today, if you'll see on the plans, provide for a roadway access point coming straight down the middle of where the solar array would be. So the condominium documents between units 1, 2, and 3 would be amended. Right now we show an 8-foot access to the side of that unit. So the condominium documents, should this get approved and move forward, we draft those amendments to reconfigure the access point. It's been expressed to us that that property owner doesn't have any plans to develop that third unit. But we would have to make sure that they have access, and that would be also part of a conversation with the land trust, because they will be the eventual owners of, and with all those rights to unit 2. But so they'll be involved in that conversation about what the condominium documents say. But for now, we've showed that access changed, and then the documents would be done at the same time.
Thank you.
Okay, board members, do we have anything else? Hearing no response. Attorney Roca, do you have another witness?
I do. So we have Ed Pimentel should be on the line now.
Okay, thank you.
Ed, oh, there you are. Oh, nope, okay, there you are. Please state your name for the record.
Can you hear me?
Yes.
Yes, hi, this is Edward Pimentel. That's spelled P as in Paul, Imentel.
Go ahead.
Yeah, so, I mean, I know I've been before this board on many occasions with solar projects. I am a proponent of solar. I do a lot of solar development in the state. Early on, I was involved in several projects before this board that did involve zone changes. And I know that the sentiment was that really solar should not be located in residential districts. And clearly residential districts that should be more so preserved for residential development with the tree disturbance and so forth. I removed myself. I haven't pursued a residential development solar project statewide since a number of projects ago. The last several projects that I've done in this community or any other community have either been by right, or those that now is where we are hoping to basically pursue and locate solar. And so there was quite a bit of sentiment that went out statewide and a pushback on the state too with their advisory documents. And what the state did in 2018, 2019 was to then go around to the communities, primarily rural communities, and engage in work discussions, including the town of Hopkinton, and to come up with a game plan, maybe a preferred game plan that would satisfy helping to introduce and still accommodate solar, because our goal is to have a certain percentage of renewable energy. But more importantly, to also assuage the concerns of these rural communities and what was happening. So what I would like just to note for the record is that, curiously enough, was that subsequent to those hearings, the town of Hopkinton also likewise amended its own solar ordinance in 2019. And that was the only reason why I felt comfortable in jumping into this project, because I said I would not pursue another zone change in the town of Hopkinton. I heard loud and clear from the planning board and the council, we just don't want to see solar in residential areas anymore. And the only reason why I felt that this was very appropriate, it was that like I was saying before, subsequent to those town meetings, the advisory documents that were put out by the state noted that what we should really be doing is pursuing solar in areas that are commercially zoned or industrially zoned, areas that are disturbed, perhaps unique things like parking lot structures, carports, and in areas that are either currently operating or formerly operating as gravel banks, quarry sites, sand pits, contaminated sites, brownfields in other words, and in areas that potentially are non-conforming, and we would like to extinguish those non-conforming rights. So what did the town of Hopkinton came on the back end and rewrote their ordinance and stated, and I want to quote, some pre-existing uses in residential zones with difficult redevelopment potential may be appropriate in desirable areas for solar, such as gravel banks, and may warrant special consideration. In fact, it states for streamlined review, regardless of district where they are located. And in the subject instance, this talking about former sites. as has been conveyed to me by property owner and everybody alike, this is still an active quarry. It may not be a highly active quarry site, but it is active. It has not lost its grandfathered rights. So here we have an opportunity to extinguish a quarry, an operational grandfathered quarry site in perpetuity, number one. Number two, this is where now the new regulations want to see solar facilities located. And then the final, really the clincher here was that not only are we going to comport with all the dimensional requirements, but that we're going also in perpetuity then to extinguish the development rights to this property, regardless of the now imposed commercial special district designation. And at the end of the life cycle of this temporary usage of property, it's going to be now added acreage to that which is protected in perpetuity in the town, which is another worthy goal that's noted in my comp plan. So that was the reason why I felt it was very, very appropriate that this zone change could be supported. And I could argue that it was consistent with the comp plan, because this ordinance amendment in 2019 that went through the planning board process and eventually to the town council got adopted, this was rendered and realized as consistent with the comprehensive plan. And clearly it was, because it's taking it away from the true sites that are residential, sites that are not disturbed. We're avoiding large tree disturbance. There's very minimal visual intrusions here. There's hardly any neighbors, given all the environmental constraints surrounding this property. And we're taking another potentially non-conforming usage of property off, off for future concerns and considerations. That's why I felt it was appropriate with the council to support this, and that's why I feel very appropriate that I can support it tonight and contend that this is in fact very consistent with your comprehensive plan. I don't know if the board has any questions.
Okay, thank you.
Thank you.
You're welcome. Attorney Roker, do we have anything else?
Sure.
Perhaps I should ask the planning board if they have any questions for Mr. Pimentel.
This is Emily. I have a question. Ron.
Sure, go ahead.
So I appreciate that explanation, and I accept the premise of what you're saying about, replacing a gravel bank use, which is non-conforming within a residential zone, and extinguishing it permanently. Why not just put, place panels and design the project so that it sits within that already disturbed site of the gravel bank? Why, add additional panels beyond that spread that limit of disturbance further into the rest of the undisturbed portion of the site?
I'm sorry. The thing got unmuted, got muted again. I do apologize for delaying my answer. So there's a component of this that clearly the other experts could testify to as well, but there's an economic feasibility component to this too. The project can only be reduced so much before it's not economically feasible. And that's a more of a reality that can be testified to by the other experts. But that's point number one. Point number two is that the gravel operation in itself isn't just limited to a specific area. It's grandfathered on the property. So if this gravel bank, or I should say quarry operation, to be more appropriate, ever really wanted to materialize to a greater extent, I would think it would probably end up being a lot more disturbance on this property than extinguishing it where it is at the current moment. So yes, there will be a little bit more disturbance, but the project has to be economically feasible. And number two, it will be a lot less disturbance than potentially what could happen in the future, from my professional opinion. And that's why I think this is a good balance of what we're proposing. And by the way, we have reduced it even furthermore to the extent that we can, once again, from a project feasibility perspective, because I learned, like I said, my last several projects before this board have all been by right projects. The Main Street, Frontier Road, and I know what's going on with those projects, but we listened far and wide to the board. You're concerned about imposing the 100-foot setbacks and so forth. So we've accommodated everything we believe that we need to do from a regulatory perspective to make this dimensionally compliant. And to that extent too, because it is zone commercial special, we also have we're entitled to some development rights to the property as well under that. But it's got to be project feasible too. And that's why we need to, at least from the perspective, because we have reduced this down to the extent that we can.
The only other thing I would add to that is that you probably recall, but we, at pre-app, this project had gone out and towards that area. The council, based on feedback from the Wood Pawcatuck, and we moved it, we condensed it further north to that area so that we could get as far away from the river as possible. And Wood Pawcatuck signed off on that, as did the land trust. And that's kind of the result of that pushed up area away from those features. So that's also part of the thought process and the design here, by way of the background.
Okay, thank you. Emily, does that answer your question?
Yes, thanks.
Okay, you're welcome. Thank you. Any other board members have questions? Hearing none. Attorney Roca, do you have anyone else that you would like to have heard?
Yes, just
Okay,
briefly.
proceed.
I have Kelly Conley of Terra Inc. You have a preliminary report and preliminary landscape plan from her. It's a concept plan, but I think she can probably help speak to what's out there. Some members may be aware of what the site looks like, but that may be helpful to put into some context and answer any questions we have at this point. So I'll turn it over to her.
Okay, thank you.
Good evening. Thank you so much for your time. I'm guessing that you can all hear me appropriately. My name is Kelly Conley. I'm a principal at Terra Inc. I'm a landscape architect. We are registered in multiple states within New England and into New York. What I have submitted was a memo speaking to my site reconnaissance to look at the property and the materials that exist as far as vegetation, especially as it pertains to the area of disturbance and clearing, the 100-foot setback that was requested. What I would say is what's really interesting about this site is that as you move in from Chase Hill Road, you drop into what will be the eventual solar field site if this project is approved. So topologically, we drop from residential road level in through a grove of white pines that are secondary growth, a little bit of a wet area, which is in the northeast corner is where the detention basin will be located for the project, where I'm seeing more sort of hydric plants. So those are things that like to have a bit of a wet soil, and growing more as an understory. Those would include alders and serviceberries and salix, pussy willow, that have a canopy of the oak and red maple. Once you move through that field into the project site, you end up in an open secondary growth meadow that had clearly at one time been mown down, used part of the operation of the quarry. Interestingly, in that area, it's a lot of secondary growth that's more focused on small softwoods like beech and birch and black cherry, some white pine, but very little evergreen. And then some young shrub species like dogwoods and viburnums, cedars and azaleas, with the majority of that matrix being grass and herbaceous species. Since the topography rises to both the east and west of the site, the landform itself is creating sort of a visual edge and barrier for views in or out, unless you're on top of a ridge type condition. So it's kind of a bowl with these very large canopy hardwood species like oaks and maples along the edge. As you move to the southern end of the site, you again have a similar sort of large canopy hardwood species, very little undergrowth because of the deep shade. So what I would say is that most of the site does not have a lot of intercepting shrubbery per se because of the tree canopy, except in the area of disturbance to the southeast where a lot of the quarry activity is happening. And there you're getting a little more shrub species that have come into the matrix. So that's sort of my overview of the vegetation cross-section. And interestingly, I just think that the landform, the topography, is a real ally to screening, as well as maintaining the quality of the forestry that's there because of how the slopes move and the mature nature of the species on those banks. So I'll take any questions if there are any.
Okay, thank you. Board members, any questions? Please respond.
Hey, this is Carolyn. I don't have any questions, but during the site walk that we were invited to by the Conservation Commission, I thought to myself, you couldn't have picked a tougher piece of land to be installing a solar installation in. So kudos to you guys for finding a way to make this work. I think the effort that's going to be involved in cleaning up the site is going to complement the end game of all of the opponents, in that it is going to improve the quality of the growth around the area just because it's going to be cleaned up. I appreciate the effort that's been put into working with the groups, the other commissions in Hopkinton. So that's the end of my comment, and thank you.
Thank you, Carolyn. Anyone else?
This is Emily. I guess I'd ask a follow-up question about that. Carolyn, like, just alluded to cleanup. Can you talk a little bit about the extent of the cleanup, the nature of the cleanup, what would be going on for site prep?
Right. So I think there's probably one main question is, as I understand it, there's some some remaining things out there or on the soil. I think that's probably, I don't want to assume what Ms. Light was referencing, but to prep the site, we probably, and I can let the professionals speak to this too, rake that site and to the extent possible, which would hopefully clean up a lot of that, a lot of those items. Again, we haven't gotten to the construction level detail of what will happen out there and what needs to happen really for the installation and the planting of the grass underneath it. But that's, I think, what she was asking, but I don't want to assume that it was a different question.
Does that satisfy your curiosity, Emily?
Well, I mean, it kind of makes me even more curious. Carolyn, do you want to describe what you saw?
It's not what we saw, it's what we know about the history of the property.
Okay. So.
Okay, we've talked about the potential to have to remediate the land and potential soil contamination. So that's part of the town council's conditions, is that the property be inspected for that and the remediation be completed before they can execute the plan to do the installation. Am I right, Joelle?
So the condition is that to the extent DEM requires remediation for that use, that we complete the same. I can tell you that as part of really the feasibility and the financing of this project prior to the building permit being pulled, we will have to do some if not before that, right? Because you only want to get so far in this process, do some type of further we have done some investigation, but it is the historical use of the site that's the question mark. But we'll do some testing and investigation at that point and coordinate with DEM and follow whatever process they require as far as an investigation report and taking it through their regulations from there before this thing is up and running. And if anything needs to be done, that it's done with the site prep for this project. So that's the plan.
So to flesh this out a little bit, it sounds almost like there's a, let's call it an inspection protocol from DEM, where they'll be monitoring the progress of the cleanup and remediation from time to time.
So in your normal project, it wouldn't trigger DEM. I think let's think, right? If you were going to go build houses on this site, or like any project, you need financing for this, and they're going to want that done anyway. So that would trigger us to do testing on this site. It's at that point, depending on what that shows, it depends what DEM process gets followed. So the condition from the town council was to perform remediation if and as required by DEM. So that would trigger or not trigger a process through them. And that would be the regulations, the specific regulations we have to follow from there. And the professionals would have to sign off on that on both ends.
Okay, thank you.
Mm-hmm.
This is Emily. It sounds like that's a pointless condition by the town council, though. If DEM requires it anyway, you guys have to do it. So, right? Am I interpreting that correctly?
No. So they wouldn't. There's no outright requirement, right? We're gonna need to do some testing before we get our building permit. Period. That would be. Then I think the idea was that, which you're right to a point, and that if the testing shows something, we got to go through the DEM process. There's no way to avoid that at that point. It's like a triggering thing, and that would their process and their regulations and whatever's found in that investigation would determine what happens, right? So you're not building houses at this site, so it's probably a different protocol. And so solar's built on all kinds of sites throughout the country, and there's different things that may mean topsoil, that may mean the construction process is different. It depends really what shows up, but the project's not going to be in a situation where you can start putting it up without doing that due diligence which is exactly what it is before to get the funding to do this.
This is Emily again, just out of curiosity. Did the land trust have any interest in contributing to what their opinions on what testing is done and what is, to what level it's remediated? So I understand like there might be different levels of remediation depending on the site use, and DEM might say like, oh, well, it's a solar array. It's not like it's houses, so a little bit of contamination is okay. But will the land trust have an interest in that, and will they, or have they expressed that interest to see a level of remediation above and beyond what is required for a solar field, because they will be the future tenders of that property?
Yeah, no, they haven't yet. I think they're on the line, so they can weigh into that. I think the future use is kind of a public access and a public, and you said something about the quarry. They did bring that up or the Conservation Commission, one of them did. We've had so many conversations that they're intertwined at this point, but about how the quarry site is something like public that is interesting to see, and the ledge and all these features out there. The land trust envisions this property going forward as a sort of a meadow, which will be how we plan this going forward post decommissioning. So they haven't raised that issue. I don't know well enough the DEM regulations to say that remediation, if needed, you know, there's levels, right? Residential housing is the top one. And then it's, what does that mean? But we can certainly look at that with them as the process moves forward.
This is Carolyn. Emily, I think the proximity to the Pawcatuck River is something that the DEM is going to have their eye on when they do their analysis. And that's some of what I was referring to earlier. It's a great piece of property. It's got great views from the hill. It's a tough place to put a solar project, but in my mind, the potential for the remediation and the impact on the forest and the river, everything trickles down to somewhere. So if there's contamination, this is a great opportunity to get it cleaned up, because the Camoli project could be supported by the grant funding available through the state.
Great
Thank
point.
You.
This is John. I'll just follow on to this line of questioning because I'm curious. I know I would feel more comfortable if I were aware of what type of testing is planned to be performed. I realized from the Conservation Commission document that the intent is not to test until after master plan approval. But I think if the board had a sense of the types of testing that will be undertaken, when they will be undertaken, and kind of steps that might go from that. I get that the DEM requirements will dictate that. It would put my mind at ease. I imagine it might put others in the same condition.
Right. So I can assure you that I won't have that answer for you at master plan because the financing partner isn't involved, and so that they will really dictate. It's really how stringent. It's not. People don't fund these projects by saying, yeah, here's a blank check. We don't know anything about the site because of the liability. So it's how intense it's going to be is the question. But it's really, there's nothing been found, no red flags yet with the studies that have been done on the site other than the historic use of the property. So that's at least a good start, hopefully. But I don't know exactly what that testing would be. We wouldn't do anything really until it's a feasible project to spend the money to go down that road. I can see if this project progresses to preliminary, what we can get you from a level of detail on that. And I don't know if Jason has anything to add, but I don't know that we know the answer to that question yet.
Yeah, I can fill in a little bit. It's true that we don't have specifics on that yet, right? We're not that far along, but just generally speaking, I think to answer your question as to what kind of testing would be done, just, generally speaking, it would consist of soil and groundwater testing, and the testing that would be done would be consistent with the historic use, right? So what kind of contaminants might you find with the historic use of a junkyard, right? So those are the type of contaminants that would be tested for. And then the general process is you test the locations that are most likely to have an impact for the contaminants that you're most likely to find, right? That's what you're looking for. And then if you get a reportable concentration, then it gets reported to DEM. And then what happens from there is now DEM's asking, looking at what we tested for, and is that sufficient? Is there additional things they want tested for, additional locations? So that process, kind of develops as the project goes.
Thank you.
This is the problem with Zoom. See, he could have kicked me and given you the better answer.
Okay. Do we have any more questions or any more comments from the planning board? Hearing none. Attorney Roca, do you have someone else?
We don't. We'd like to hear from the public. I will say you'll probably hear from the Conservation Commission, and one thing that's in their report is regarding the fence issue. We've been working with them on this to find some happy medium between your typical chain link fence and something else. We've looped in the fire marshal and gotten a further understanding of what his requirements are. So as the project progresses, we're hoping to put our thinking caps on with the fire marshal and see if there is some other type of fence proposed. I know they proposed a farm fence that wouldn't have been approved because it's a safety concern at the site. That's heightened on this site, I think, by the conservation easement that's going to be in place as the project's up. So the safety concern is sort of heightened. I think everybody from the land trust perspective and other groups that weighed in don't want to see barbed wires on top of the fence from a liability standpoint. That's not really an option anyway. But I think there's probably a great option out there that will work with everybody to try to figure out the best fit for the site that works for all the parties. So I didn't want that to go unseen. I know they have a lot of other comments that we can go through as you hear from them.
Okay, thank you.
Thanks.
Jim Lanfair, our town planner. Do you feel comfortable with moving on to the public comment?
Yes, I do, Mr. Chairman.
Okay, let's go ahead and do that, Talia. If you can start getting people punched in, and we'll go from there. Hear what they've got to say.
First, member of the public, Mike Windsor. Please state your name for the record after pressing *6.
Hi, can you hear me?
Yes.
Oh, good. I'm actually Sarah Windsor, not Mike Windsor. I don't know why that came up like that, but I'm a member of the Hopkinton Land Trust. So I was just going to comment on behalf of our involvement in this project thus far. Should I go ahead?
Yes.
Yes, go ahead.
Sure. Yeah, I just wanted to comment that from the beginning, this property has been of interest to the Land Trust for a number of reasons. I mean, one of which is that it abuts property that we already own. It's near the river. It has this amazing ledge and great rock formations and stuff. So many years ago, we were involved in looking at this property and thinking about purchasing it, even in that condo situation that was in. The junkyard stuff and the quarrying things that were already going on to it, you know, was definitely a detriment to us. And we were put off by that. We did have some queries go in with DEM and stuff, but we kind of backed off of it at that time. So when we heard of this happening with this use of a possible solar thing and Mr. Kamoli's interest in donating the land ultimately to the Land Trust, we did think of it as a win-win situation, just because, you know, we don't think that solar belongs everywhere in the town, but in this case, there's not a lot of abutters. It's, you know, in a unique situation where the quarrying and the junkyard had, you know, already created somewhat of a brownfield, which definitely is something we would be more positive about. And, you know, the option of finally being able to have the land at the end of it, the decommissioning, was really positive. So we thought, you know, if you're going to have solar, let's try to do it the best way possible. And this really seemed like a good combination of things coming together. So our conversations with Joelle in particular have been very positive, you know, really interested in making us feel comfortable in being involved in it and working with our lawyer, John McCoy, on the easement, and then working towards a fee simple arrangement, ultimately, if this happens. So yeah, we felt pretty good about it and are supportive of it. So I guess that's all I wanted to say. And as far as the DEM issues and, having the land checked out, that's important. But, better to have these guys clean it up than us having to clean it up, which is what we were thinking. We didn't want to take that on particularly, but if they take it on for this purpose and then we get it at the end, then that's all good. And it would just be for public recreation, hiking, definitely. We were envisioning a meadow and trails around that going up to the ledge, and beautiful views from up there. It's really lovely. So yeah, thanks.
Okay, thank you. Talia, the next one, please.
Next member of the public, Carol, please state your name for the record after pressing *6.
Carol DeRogers. I guess just listening to this, I'm very confused by what may actually happen for cleanup of the property. It sounds as if it may not need cleanup if it's being used for solar. That's kind of what I'm hearing, since solar, whereas for houses, oh yes, it would probably absolutely have to be cleaned up. But I'm skeptical that there may actually be no cleanup required if it's going to be used for solar. And then what will be the impact to this going to the conservation, for the land trust afterwards? I think Emily maybe alluded to this. Do they then inherit a different cleanup regimen when it's no longer solar, but becoming public space? So that's very confusing and unclear to me. That's all.
Yes, that's a good point. I guess, Talia, we can move on to the next person.
There isn't anyone, Ron.
Wow.
Oh, never mind. Eric, please state your name for the record.
Hi, it's Eric Bibler. I have some questions. Really like them to be answered, if possible, through the chair to the a couple of these to the planning solicitor. One question I have is whether or not this project will require a lot subdivision, and if not, for the guidance of the planning board, could the planning solicitor please refer to the appropriate section of the Hopkinton town ordinances that allows a land condominium to be split zoned? From prior hearings on prior projects on 2 different occasions, the former town solicitor said absolutely that in order to split zone property on Woodville Road and on Chase Hill Road, those properties would need approval of a lot subdivision from the planning board. And we seem to just skip over that step here, and I have found nothing relating to land condominiums that makes them any different. So I would like to confirm that point to stay out of trouble. And I would really like the planning solicitor, perhaps between now and a future meeting, advise the planning board on that point. I think that's prudent. Any response on that, or should I move on?
Attorney Hogan, do you have anything to say on those matters?
That's at the chair's discretion, but why don't we hear what the other questions are, and perhaps I can answer them at once.
Okay.
Okay, good idea. All right, Mr. Bibler, go ahead.
Then another question I'm very confused about, really kind of a procedural question. This proposal is being evaluated under the PSES that was enacted on January 22nd, 2019. I don't think there's any dispute about that. In paragraph 13 under general requirements, this paragraph that relates to residential property that's rezoned states that If the parcel is zoned RFR 80 and the applicant is seeking to rezone the parcel, then the maximum requested coverage may be the lesser of 3% or 3 acres. I believe the applicant just said this was now going to be a little bit more than 8 acres. I don't see anything in the ordinance here that permits the town council to make a different determination. Under normal circumstances, if you have some kind of a zoning ordinance, and you don't want to adhere to the requirements of the ordinance, you have to get a waiver. So I'm just really confused how it is that the town council is able to violate this restriction that's never been explained. No waiver has ever been asked for or granted. You know, further down in the paragraph, there's language about during the advisory phase, the planning board may recommend a different lot coverage ratio based upon the unique characteristics of the property. And, you know, as was admitted during the town council hearing, the planning board not only didn't make that recommendation, the planning board voted unanimously to render an adverse advisory opinion. So that can't be the source of the town council action. So I'm really curious, again, what authority the town council has to violate this provision, because one of the findings that the planning board has to make is that this applies to the first question too. The planning board has to make a positive finding that they have full confidence that this application conforms, you know, complies with all the town's ordinances. And these are two examples where I think it's far from clear. So I'm at a loss to see how the planning board's going to make a positive finding in these two instances. And then I'd like to go on. I have one more question that relates to this kind of very unusual situation where the town council has jumped in front of the planning board, has made a lot of, you know, conditions that are really more germane to master plan process, but they unfortunately, you know, performed these various acts and conditions, you know, before any master plan application was filed. But what I'm particularly confused about, and I think perhaps the solicitor can answer this one tonight. I don't think it's complicated, but I think it's undisputed that the town council granted conditional zoning approval for the requested comp plan amendment and the zone change. And I think it's also undisputed that that conditional approval of the town council will only take effect if the project achieves all of the other approvals of the planning board that are required. So this conditional zoning approval is subject to all necessary further approvals of the planning board. We also have talked at length, and planning solicitor Hogan has advised this board that it's very important that the board make those required findings. That came up earlier tonight. So my question is, did the town council's conditional zoning approval, and that's for zoning, not for a plan, but did the conditional zoning approval by the town council, does that require now the planning board to make a positive finding that this master plan application is consistent with the comp plan? If so, I'd like to know how and why, because it would seem that the town council's action on zoning, which is conditional and unrelated, would be prejudicing the work of this board, the authority of this board. And I as a resident, would want to know that the planning board is very clear about whether that authority has essentially been taken away from them and decided for them, as has been implied in the past sometimes, or if the planning board, can exercise its full independence and possibly reach a different conclusion than the town council reached about the consistency with the comp plan. So what are the rules of the road there? Lastly, I think it would be appropriate on September, I just want to note, first of all, that on September 2nd, a conceptual plan, or, I guess a concept plan was put in front of this planning board for this project. It was a little different, setbacks from the river were different. There were some different things, but the location was approximately the same. The scale was approximately the same. It was a little larger. I think it might have been 13 acres. But the real question on September 2nd for the planning board, in the furtherance of their rendering an advisory opinion on the requested zone change and comp plan amendment, the question was whether or not these requested zoning changes were consistent with the comprehensive plan. The planning board voted unanimously 4-0 that the proposed project was not consistent with the comprehensive plan. And they made very detailed findings. I'm going to spare you, but I really, as part of my question, I would like the planning board and the planning solicitor, but really the planning board, to refer to them. And my question is, as I go down this list, I don't see how anything that has happened at the town council or any changes here that have these tweaks to the plan, I can't see anything in all the progress that's been made since September 2nd. I can't see anything that has resolved any of these objections. I mean, just to read one, it's not, first one is goal con 1. It's not consistent with the conservation of Hopkinton natural resources, particularly the protection of the ground and surface waters. Goal con 1, I think there's maybe 8 of them, 3, 4, 5, so there's 7 of them. So I would respectfully ask that if the applicant has succeeded in transforming this project and making the project that was previously unanimously rejected for 7 specific reasons, my request as a resident, and I think it's completely fair, would be for if the planning board does decide to approve now this project, I would like to ask the planning board to address each single specific prior objection and explain why that objection no longer applies and how it's been resolved. Because if it hasn't been rebutted or resolved, it still pertains as far as I'm concerned, and you haven't really justified a finding that is completely categorically the opposite of what you found a few months ago. So that's a lot of work, but I think that it really gets to the heart of the matter. And if we don't resolve these issues and drift through this, many of these things are going to apply to other proposals. So I think it is important work to do, both generally and specific to this project. And I apologize for going on for so long, but I think all these issues are very important. Thank you very much.
Thank you. Attorney
Chairman,
Hogan, do you have?
Yes, do you wish for me to respond? I believe I have all
Yes,
the
please.
questions written down. Okay, item number
Yes,
1. Thank you. Item number 1, the question about the land condominium. Condominium is a form of ownership. It is not a subdivision. Land is not required to be subdivided in order to be developed. The land condominium is in fact an adequate and appropriate mechanism. It is not well known. It is not often used, but it is a mechanism that is permissible under Rhode Island law. It's a question regarding the max coverage under the PSES. To the extent that the town council has changed the rules of the road, the planning commission has no opportunity to object to that. We do not sit as a superior court. We do not reverse a town council action. We are presented with a zone change that has specific conditions and permissions, and we have no authority whatsoever to deviate from those. As difficult as that may be, place the planning commission, or pardon me, the planning board in a difficult position. That's the rules of the road. We're not the superior court. There is no stay from the superior court telling this board that it shall not act on this application, and it has no authority to ignore what the town council has done. The question about the concept plan being in front of the board, not having been consistent with the comprehensive plan or the zoning ordinance, I would respectfully point out the fact that the comprehensive plan has now in fact changed. The town council did that. And also the zoning ordinance has now changed. And so this application is before the board for a full evidentiary hearing on all of the requirements that an applicant has to meet. Whether or not it meets its burden, it remains to be seen, but that will come out in the end when the board makes its decision. And the final thing was, would like the planning board to address each and every prior objection specifically. I would respectfully indicate that the board will follow whatever appropriate decision-making responsibilities that it has, and it will do so in accordance with state law and local regulations. Whether or not that rises to the level of the requester's satisfaction remains to be seen, but certainly the board is going to discharge its duties fairly and legally and with all due dispatch. That concludes my response, Mr. Chairman.
Okay, thank you.
Welcome.
Now, where do we go from here? Do we?
So my next question for the board, or subject for the board to discuss very briefly, would be the same as that we discussed at the last meeting. Now, I know a couple of you managed to tag along with the view that was done for the land trust, but again, I would suggest to the board that a view of the property, a personal view of the property, a tour of the property would make a lot of sense. I suspect that the applicant's representatives are available to conduct that, since they've conducted one for the land trust. And so is it land trust or conservation commission, or both?
This is Talia. They're two separate entities, but they were both involved in these discussions.
I was kind of tripping on my words there, sorry. So in any event, that would be my recommendation for the board to discuss that possibility.
Okay, thank you. Board members, what do you think? Want to go for a walk in the woods again? I'm not hearing a lot of enthusiasm here.
This is Emily. I'd be supportive of that.
Okay,
Keith,
what was that, Emily?
Emily indicated she'd be supportive, but I think Keith popped in, but I couldn't hear what he said.
Yeah, it was kind of garbled on my end.
You heard me thinking about what possible date are we going to agree to. We already struggled to find the first date of June 10th, so it would be after that, which I'm still fine with. I participate in full.
We had I can't remember what the date was, but there was a couple of conflicts from the applicant, which may not be applicable in this situation, but I can't recall what those dates were.
This is Talia. The date for the Stone Ridge site walk is the 9th.
Right.
But I'll remind all of
Thank you.
that No worries, Keith. It's a lot of stuff that we have to
Wednesday.
keep track of.
This is
That's
Emily.
why you're here.
I think it was Tuesday, May 25th. It was one of our first suggestions that didn't work for the Stone Ridge applicant, so maybe that works.
I actually asked that question. I'm just waiting
Okay.
for an answer.
Talia, does that give us enough time to post?
This is Talia. I don't think I've ever done a posting for a site walk.
That's okay. It's the same kind of concept. So
that needs, it needs at least what, 72 hours notice. And refresh my memory, would they have to send out, so would this just be for the planning board, or would this be, okay.
Yes. Once again, same parameters. It would be an open meeting. And I think is it a 4-day advance or is it 48 hours?
It's 48.
Thank you, Joelle. So even if we posted it by the end of this week, if we can agree on it, it's more than enough time. You know, I know you take the weekends out of it, but that would be enough time if we did it by tomorrow or the next day.
And
So
we're good for the 25th.
This is Talia. It would have to be tomorrow because I'm taking Friday off.
Okay, somebody just said they couldn't.
25 or 26. Sorry.
Okay, all right, that takes it out. All right, let's get the calendars out then. Ron, when were you away? It was the 9th to the 20th or something like that?
Yeah, I'm leaving the morning of the 10th, and I'll be back the 20th.
Okay,
So anytime after the 21st, be good.
All right,
and that's June.
Was there an issue with the first? I'm checking on my end, but I don't want to bother if.
Yeah, there's no issue on my end.
Someone
Anyone
had a
else?
conflict, but
I can't do
remember.
the first. Okay.
Okay, the first is out. Okay, how about the 3rd? That's a Thursday evening.
This is John.
Talia.
Can't
That
do
was
the
the
3rd or
day.
4th.
Yep.
Say again?
This is John. I cannot do the 3rd or 4th. However,
Oh, right.
I did walk this site with the Conservation Commission at that time, so
Okay.
I've seen it.
You've seen it, okay. How about everybody else for the 3rd?
3rd is fine, but I have seen it as well, so.
Okay. Subject to the applicant's availability. Emily, does that work for you?
It does.
Keith?
Should be fine.
All right. So we'll just stand by for a minute to see if we can get an answer from Joelle's client.
Yes, all set.
Beautiful. Okay,
So
so
we're
the
looking
details would be same time frame, 5-ish, right? Is that good? Okay.
Yes.
Yeah.
And same question, I guess, is there, just from the site plan, it looks like there's plenty of places people drive in and park, yes?
Yeah, we'll just gotta coordinate with the Unit 1 owner, but
Okay.
I can get Talia that information in a
Great.
quick turnaround to if you want to put it in the posting.
Okay, great.
Okay, so it looks like we're good to go here.
All right, June 3.
Mr. Chairman, Jim Lampier, Town Planner. I think we need to continue this public informational meeting to a date certain.
Agreed.
Okay, to a date certain. We're going to be doing this on the 3rd. I'm looking for input from everyone.
Jim, what's your schedule look like for the 16th?
I suppose we could, for the 6th, I suppose we could do the 16th.
Okay, I won't be here the 16th, but Emily's
Oh, that's right. No,
more than qualified to handle it.
no,
I'll
we
need to
need you.
recuse it.
We need you because Al's already recused. So it has to be when you're here.
Okay. So that's out.
Yep. Next one, Jim, is when? July
July 7th,
7th?
which we already have Skunk Hill and Stone Ridge coming back.
I got Joelle shaking her head. No, no, no.
Well, currently this application, Joelle graciously gave us a 30-day extension back on April the 7th. So this decision period now is good through July the 18th, as I have it. So if Joelle wants to give us consent to a longer extension, we can probably do this in August. We're only going to have one meeting a month now. Like I say, this month and next month, we got two. We're only going to have one. And we're going to have packed agendas, and don't ask me how we're going to get through this stuff. I have no idea how we're going to do it. There's going to be a lot of people waiting in line for a long period of time. And I'll tell you, the problem is the residential market is heating up right now. We're getting a lot of residential stuff. And I just don't think it's fair to start holding all of our residential folks back that want to do a lot here or 2 lots there because we have an inundation of solar applications. We almost have to pick a night and do solar stuff and let the solar people just wait in line. And however long it takes to get through them, it gets through them. But, like I say,
done. And we did that last month. We did that this month. So we're in good shape. So the question now is, what day do we want to continue it to?
Well, let's say, well, July 7th, you know what we have July 7th? Joelle said no. So the next one is August the 4th. And I'm sure we'll have a disaster that night too. But I mean, so whatever night you want to pick.
So I only say no to July 7th because you guys have Stone Ridge and Skunk Hill and out of courtesy. But what I fear is I say no, and then they both get continued to August and we're last in line. So that's.
Why don't you put yourself on the agenda and as a placeholder? And you may, after the site walk, you may be in a position for the board to render a decision that evening.
In July?
If that's the case, then, we could have Jim put that on. If it's for decision, we can do that earlier. And if if they're not ready to do that night, at least you have a placeholder and there's not a renoticing issue,
Yeah. Yeah.
And it keeps the public's eyes on, okay, where are we going next? I think we definitely need to set the date tonight so that they're not confused.
Yeah, that's fine. And I can understand if the board's not ready at that point, then we can talk about going forward.
Right, because they might want to discuss some of the things that they've seen on the site walk once they get back into the public arena, and, have a chance to think about things and have some additional questions. The other issue is, we talked about it in the last application, I think the applicant is going to be responsible for, providing some kind of video person there. Do you have the capabilities of doing that?
So I didn't know how you left that with the last hearing, because there was a question as to whether you were going to do that and post it. I have no idea if we can do that.
Okay.
To the extent we can, we will.
Right.
Other than a Facebook Live, like no one wants that. So we will, I'll work on that.
Okay, that sounds like a plan.
What about the possibility of a drone video?
What do you say? A Joe? What?
A drone.
Oh, a drone.
Drone.
Sorry.
Sorry, this is Jason Gold. We do have the capability of doing drone, but drone doesn't last. The battery only lasts for so long. I don't think it's going to cover a whole site meeting.
Oh, okay.
But I'm sure someone could videotape something.
Okay, thank you.
I sound old. Videotape. We could record. We'll figure out some way to record. Does just a question? Does Hopkinton have a like a local cable access that records public events?
I have no idea.
This is John. We don't
Yeah,
have
yeah,
television
go
screens
ahead.
to project in town hall, so I don't think we have a camera
Okay.
system either.
Okay, so are we locked into the date on the revisiting this? Are we looking
Right.
at August 4th or July 7th?
So we're looking at June 3rd for the site walk, and we'll continue this
Yeah.
to the public informational meeting to July 7th, and then we'll go from there.
Okay, understood. Thank you.
Thank you.
Thank you.
So we need a motion. This is Emily. I'll make a motion to continue the public informational meeting for Camoli to July 7th.
Okay, we have a motion. Do we have a second?
Second, Keith there.
Okay, let's have a vote. Planning board members, count off, please.
John, yes.
Keith,
Emily,
yes.
yes.
Brillwitz, yes. Was that all of us?
We're missing
Yes.
I don't know
Carolyn.
if I heard a Carol.
Nope, I heard Carolyn. Carolyn
You
said
did?
yes.
Okay. All
She
right.
said yes after Emily.
Okay.
Okay, then we're good to go.
Very good.
I guess at this point, I'll turn the meeting back over to Al, and he can finish us out for the evening.
This is
Thank you,
Talia.
everyone, for your participation.
Oh, Ron.
Go ahead, Talia.
Ron. Al
Yes.
has departed, so it's you for the rest of the evening.
He's departed. Okay,
Yes.
He has left the building.
Elvis has left the building. Okay. Moving right along. The next item on the agenda was Skunk Hill. That's been moved. Solicitor's report.
Nothing to report this evening.
Thank you. Planner's report.
Nothing, Mr. Chairman.
Thank you. Correspondences and updates. Would that be Talia?
This is Talia. So normally at correspondence and updates, the chair will ask if any of the planning board members have any questions or comments on the correspondence that was received. So you can just say that.
Oh, okay. Any questions or comments on anything that was received that's on the agenda for tonight? In the correspondence segment? Hearing none. Public forum. Oops, somebody spoke.
That was me, Ron. Sorry, it's Maggie. Just that you just make a note that those the correspondence is placed on file in the for the record of the meeting.
Oh, okay, thank you. I need to do that, or
No, that's all right. We just acknowledge it, publicly that that's, that it forms part of the record of the meeting.
okay, thank you. They are on file and it's part of the meeting. Public forum.
We have one person. Please state your name for the record. Last four digits, 8222.
Hi, this is Joe Moreau. I appreciate your time. I know it's been a long meeting. I only need about 5 or 6 minutes because I have some very important issues I need to discuss. I have some facts to discuss, and also I want to discuss a federal crime that was committed. I guess since the Hopkinton Citizens Alliance was dissolved in February of 21, we now hear from the Hopkinton citizens responsible for planning, or I should say from Mr. Bibler. I don't believe I have ever referred to Mr. Bibler by name in any of my comments before. He continues to mention my name in emails sent, sometimes to my home. He sent something to my home with the town's address as the sender. And on May 10th, 21, violated a federal law by putting something I sent to him in my mailbox. A person could be fined up to $5,000 for this. If I had a pending issue like Mr. Bibler has, that would be the last thing I would do. Someone had forwarded in an email recently in which Mr. Bibble said the following. Even though some Hopkinton citizens, including Joseph Monroe, have publicly urged the planning board to approve the massive Stone Ridge solar project, it seems clear that regardless of the zoning, this proposal is utterly inconsistent with both the town's comprehensive plan and the solar siting guidelines of the state of Rhode Island. I never said that. You can look at the planning board meeting for May 5th, 21, started 2.08 to hear what I said. In the same email, Mr. Bibble said the following. I do not believe that there is more than a handful of Hopkinton residents other than Mr. Moreau and members of the Hopkinton Conservation Commission. And he goes on to make some other points. That is not true either. The third point is that in another email, Mr. Bibble said I was a vicious rumor-mongering gossip. Also not true. In a recent email, Mr. Bibble referred to Stone Ridge as a 92-acre sea of glass. I stated at the 5-5 planning board meeting the actual size is 81.33, and I confirmed that by a town official. Mr. Bibble continues to present false facts to the public. Mr. Bibble also stated at a meeting that Stone Ridge would be the largest solar array in Rhode Island and maybe the largest in New England. On June 22nd, 2020, North Smithfield approved Rhode Island's largest solar array, 38.4 megawatts, 400 acres with 160 acres of panels. If my math is correct, Stone Ridge is not the largest solar array in Rhode Island. Again, false facts were presented to the public about Stone Ridge by Mr. Bibble. A resident did some research concerning Mr. Bibble's action. One of these was in a newspaper article dated June 5th, 2010. The headline said, Eric Bibble to the grassroots, go for the juggler. Wind power simply does not work. Can you imagine someone saying go for the juggler? On February 3rd, 2011, Mr. Bibble made a statement to the House Committee regarding industrial wind energy. Mr. Bibble said, my name is Eric Bibble and I am a full-time resident of Western Connecticut. Of course, we all know Mr. Bibble is a part-time resident of Hopkinton. One final thing I wanted to read to you. This was to the Yarmouth Board of Selectmen from Joyce Flynn, reference October 11th, Eric Bibble and Peter Kenley, allegations. October 17th, 2013, I'm writing to call your attention to the deliberate misrepresentation by Eric Bibble and Peter Kenny of a recent letter from Rebecca Tepper at the Mass Department of Public Utilities to the Cape Cod Light Compact. She goes on to say some other things, but then she also points out this factual context is
Mr. Prowitz,
Yeah.
I'm sorry, I've got to interject and I apologize, but Mr. Moreau, this is not the forum for listing of these grievances. And if you don't have anything else, I think we need to just stop.
Well, you are certainly the attorney. I know other people try to be attorneys, and I respect what you have to say. I will not continue reading the rest of this where he distorted the facts. I'm surprised, though, because, you know, other people are allowed. It's public forum. Other people are allowed. I do, and I've asked this question before, I do have from Kelly O'Rourke, Title 42, State Affairs and Government, Chapter 42.6. Nothing within this chapter shall prohibit any public body or the members therefrom from responding to comments initiated by a member of the public during properly noticed open forum, even if the subject matter of a citizen's comments or discussions were not previously posted, provided such matters will be for informational purposes. And what I wanted to talk about was informational purposes.
Right, Mr. Moreau, that talks about whether the board can respond, and I'm going to advise all of them not to respond at all to these comments. But this is is a public meeting. It's not a place for us to make complaints about other citizens. The board has no authority to correct or do anything about anyone's behavior or what they say or do or what they put in someone's mailbox. It's just not something that's properly before this board.
Okay, I can understand that. Can I continue with some facts concerning the projects and what was said tonight?
Yes.
Okay, thank you. I appreciate it. I got to skip down. The witness tonight, Linda Steer, it said tonight that the unfragmented forest was 500 acres. As I, for the Stone Ridge project, as I said, I was confused because I could just about hear that, but you graciously confirmed that it was 500 acres. Mr. Bibble had said the Stone Ridge Master Plan application proposes an 82-acre solar project on 252 acres, which would clear cut 100 acres of an expanse of unfragmented forest that is over 1,000 acres in size. And that same email, he also said 1,300 acres. So I'm just confused what it's all about. But unfortunately, I am being restricted as what I can say. But in closing, the members of our planning board are intelligent residents who volunteer their time to accomplish what is best for our town. When we have such a prolific emailer, it makes your job more difficult to decide what are the true facts or the deliberate misrepresentation made by one individual. Our planning board and attorney could be working on other things to improve our town. For an example, grants, Stubtown Road, etc. I appreciate your time, and I would hope in the future that there are some restrictions as far as time when residents are allowed to speak, because for someone to go on for 8 minutes to make his point and then another 12 minutes and ask the same questions, I hope that we can resolve those issues. And I'm disappointed, but I understand your comments. You are the attorney. I am not. And thank you.
Thank you, Joe. Talia, do we have anybody else in public forum?
We do. Colleen, please state your name for the record after pressing *6.
Hi, it's Colleen. Can you hear me?
Yes.
Thank you. I'll be very quick. Thank you so much for taking me. It's Colleen Steffen, Hopkinton resident. I just wanted to say that today was very educational for me to hear about these projects. I wanted to just also say that I'm very strongly opposed to large-scale solar, and not in a way I love solar. I do believe in the value of solar where it's correctly placed. My concern is setting a precedence for other kind of projects that come up, and just on that kind of that alone, just setting a precedence about how we treat solar and how we approach solar and what kind of projects are coming before you. Like you said, it's kind of impeding other projects that you already have on the table, and these have gone on for so long. Just to consider how these could be expedited in the future, just in the careful consideration about the ones that are coming up today. That's really all I wanted to say. Again, thank you so much for the very, very intense amount of time and effort that you put into this, and have a wonderful night.
Thank you. Talia, do we have anyone else?
Yes. Eric, please state your name for the record.
Hi. First of all, thank you, Solicitor Hogan. Just wanted to address a couple factual points. For Stone Ridge, when the proposal first came in, it was 127 acres. The applicant, Mr. Sharenzi, on behalf of the applicant, provided a project narrative to the planning board that was dated April. And in the project narrative on page 3 at the bottom, it described the solar field as 92 acres. I think, not sure where, but I think the amount of clearing exceeds, the enclosed area. So that's where I had mentioned at a previous meeting, the 92 acres. then I think it subsequently was reduced further just in the past few weeks to 81. So I apologize for that mistake. I plucked the figure from the project narrative. As you know, it's kind of hard to keep up with these things. As far as the amount of the unfragmented forest, I was hearing for the first time tonight that the environmental expert for the objectors characterized the unfragmented forest as being 500 acres. Mr. Buford of the Hopkinton Conservation Commission issued a letter to the planning board which characterized the unfragmented forest as 1,000 acres. And I believe that one of the documents from the applicant, and I can't point to it right now, I think somewhere characterized it as 1,300 acres. Okay, so I don't know what the definition of unfragmented forest is, but look, these are honest references to documents that came into the planning board. They're not deliberate distortions. You know, as to, you know, all of the other comments, I wholeheartedly agree with Solicitor Hogan that it's completely inappropriate to be reading from people's, not just me, you know, people's texts or emails, personal emails, or, you know, whatever. And it's not right for Mr. Moreau to be making a whole raft of accusations, which it's not appropriate for me to rebut. And it's not fair to leave him hanging out there either, but out of respect for the planning board and the fact that this is completely irrelevant to what you're all about, and it's late tonight, I'm not going to do any of that. I just do want to say that this has been going on at public forum for many, many months through many, many meetings, town council meetings and planning board meetings. A lot of the references have been to a certain individual or that kind of thing, speaking in code, not using my name, but it really has to stop. It's completely inappropriate. I would respectfully beg whoever's in the chairman's seat not to tolerate this. I'm going to make the same request to the chairman of the town council. And I just will say that I have asked Mr. Moreau if I could at least a dozen times over the past year and a half, if I could meet with him, and he's refused to meet with me. I would love to have discussed some of this personally, but this is not the forum, and thank you for correcting that. Thank you.
Okay, the date of our next regular meeting. Well, I might be moving ahead a little bit. Talia, do we have anyone else?
No.
All right, thank you. The date of our next regular meeting is June 2nd, 2021. Regular meeting time will be 6 p.m. Date of next special meeting is June 16th, 2020. Go ahead, I'm sorry, go ahead. Someone was speaking? No. Guess not. The date of the next special meeting is June 16th, 2021. The meeting start time is 6 p.m. Adjournment no later than 10:30 p.m. Do we have a motion to adjourn?
Keith here, motion to adjourn.
We have a motion. Do we have a second?
This is Emily, second.
Thank you. Planning board members, how do you vote?
Keith, yes.
Emily, yes.
Don, yes.
Hurwitz, yes. Is Carolyn still there?
Yep, she just has to unmute herself.
Did you unmute me
I did.
on purpose?
No, I just unmuted you.
Did you mute
vote.
me on purpose?
No, I did not, Carolyn.
Okay. I'm a yes for adjourning. Thank you.
Okay, thank you, planning board members and the members of the Hopkinton Town Hopkinton. and good night.